So it was about 4 hours.
Good morning. The time is about 7 minutes after 10 o'clock, and today is Friday, May the 9th, 2014. We will call this meeting of the Texas Appraiser Licensing and Certification Board to order. First item on our agenda are the pledges of allegiance. I'll ask Ms. Fontana to lead us in those, if that's okay. Yes, ma'am.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible. We welcome you to the meeting today. It's always nice to have people in the audience to listen to the work that we're doing. So we thank you very much if you are with the public or an organization, and look forward to hearing from you today. We'd also like to welcome new board members to our meeting today. We have the pleasure of saying hello to Brian Patton. Brian's a public member and an engineer out of the Austin area. Welcome. We look forward to serving with you.
Thank you.
And we also would like to welcome Jesse Barba, who's also a public member and an attorney from the McAllen area.
Thank you.
Yes, sir. Thank you. We also look forward to serving with you. And I'd like to take a moment this morning to appreciate the service of some outgoing board members. And so I would ask if Ms. McClendon or Mr. Kidd happen to be in the room, if you will meet me down front, please. Let me just both down front, please. I'll open the mic for those comments.
Is this down front?
Yes, ma'am. That's good. I figured we have to be on a mic somewhere so we can understand what we're saying. So let's see if that works. Can you hear me in the audience? We wanted to take an opportunity. Mr. Kidd may not be with us today. He is in military service, and that is one of the reasons he is having to exit our public service, is he's not available for our meeting. So before I start with Ms. McClendon, who is here, I do want to say on the public record how much we appreciate Mr. Kidd's service. He joined our organization in 2012 and served through today, and we appreciate his leadership. So I'm going to leave behind with staff. In a few minutes, I'll hand it over to Tony and ask if you can be sure that those items get to Mr. Kidd. And I'd like to say how very much we appreciate your service, Ms. McClendon. Ms. McClendon has served with us since January 2011 and is leaving our organization to serve, and I hope I get this right because it's a really long title, on the Texas Speech, Language, Audiology, and Pathology Board. Did I get close?
You got very close.
Good.
Maybe a little dyslexia in there, but we work on those things on the speech board.
And I need all the help I can get in that organization, so I'm very appreciative of the fact that you're continuing service to the state of Texas.
Thank you.
Appreciate the service that you've provided us here. I want to say especially and personally how much I appreciate her expertise in flowcharts. And if you were on enforcement with me, you'd understand.
I give a lot of that to Tony.
That those shapes mean something, and Ms. McClendon educated me on that process. So I also, in a moment, after the commissioners had an opportunity to also appreciate our board members' service, to open the mic, so I'm giving you all fair warning to any other board members who may want to make comment. Oh, so I forgot to present you with what I have for you. On behalf of the board, so your fellow board members themselves, we'd like to present you with a flag flown over the Capitol.
Wonderful.
From the state of Texas, and grateful
Texas House of
appreciation.
Representatives.
Yes, ma'am.
Thank you very much.
Yes, ma'am. Thank you.
And then on behalf of the agency, we have a certificate of appreciation for your service for these over the past 3 years plus, as well as when every new board member comes on board, we take an official portrait to hang in the committee room, and when they depart, we deliver this certificate and your official portrait.
I'm very glad to get that off of the wall. Probably the worst picture there is of me, but this will hang on the wall. So.
But the more importantly, and what is not expressed sufficiently on this certificate is the extra hours of dedicated service to ensuring that in your role on the enforcement committee, in ensuring that the processes that this board manages in how those complaints are managed remains completely predictable, appropriate, and transparent. And a lot of extra hours went into making sure of that, and we very much appreciate that because it has transformed in a very positive way the reputation of this agency, and so we really do appreciate that.
Thank you, Commissioner. I appreciate it.
There we go.
Let me take a picture of you three together.
I did. I just thought if they started moving this direction, it would be more time. My thought is if we can gather around this location, it would be helpful. So there's been a request, and the mic is still open for any board members who'd like to comment to Ms. McClendon, but then there's been a request of one of the organizations to get a full board picture. Oh. And, we need all the publicity we can get, so we're going to provide them that opportunity during our meeting. The mic is open now, though, for any additional appreciation for Ms. McClendon.
May I go next, Madam Chair? Come over here. This is a token from us for your service. Oh, gosh. I didn't think I was going to cry, but
so sweet.
Yeah. What it is, they're charms, and each charm represents a certain part of your service and your character that you have lent to this institution and this agency. Thank you.
So sweet.
And your friendship.
You're so sweet.
It's just honored today.
Thank you
Very much.
Best place to thank you.
I wanted to tell you thank you too. I really enjoyed my conversations and debates and so forth with Shannon. She's a person that I think we were really in synchronization with each other, and I really enjoyed your service, and I wanted to thank you for that.
Thank you, Mark. There'll be more to come.
Okay, sure.
Shannon, congratulations on your new position and everything. You came under when I was chair. We didn't know what to expect, but obviously it was very spirited, and we brought in a lot of knowledge that we weren't aware of before. So I thank you for broadening our knowledge as to what we can and cannot do. So thank you.
Thank you. Spirited sounds.
I'll say a quick thank you to Shannon as well. It's been a pleasure serving with you, and thank you for the dynamics that you brought to the board over the last year that I have served. So thank you very much.
Okay, Shannon.
Yeah.
Okay, Shannon.
All right.
No, truthfully, it has been a good experience. The big picture is it's been a good experience, and you were a positive contribution. And certainly questioned every angle, and so we appreciate that part of the contribution. And we expect you'll be watching us on the video, too. Thank you.
Thank you. Well, if I could, we want to get a picture first, and then I kind of wanted to give back to y'all, if I could. Can I get a little help from you, Bobby? If you recall, I know this is going to come as a little bit of a shock, but if you recall at the last board meeting, I asked that we all be given copies of the open meetings and public information handbook, and we were told they didn't exist. And when I got home, I actually made a phone call, and we do. And for those of y'all who don't want this, it's fine. You can give them back, because I have plenty of people that are interested in the open meetings handbook, which will guide you through this if you don't want it. Mark, since you probably have been through more open meetings than everybody. And then also in the other book box, we have the the Public Information Act handbook, and that is put together also by the Attorney General's office, which y'all know by now, and while we're not doing the vanity of pictures, I will put my glasses on so I can see you. Thank you, Bobby. In each one of these, you'll see how heavy it is. In each one of these, I have laminated a card. My business card is not as good as some, but I laminated it so you could use it as a bookmark when you found something really exciting, or if you wanted to call me if you had a question. I am not specialized in administrative law at all, but I have done it for well over 22 years. So, you probably have one. Yeah, that's why I couldn't carry the box individually. It's hard heavy. So. Just one more on the open meetings handbook. They actually did print as well, but they ran out of the print. The legislators got those. If you want to help those out, and of course you have to have the training on those. But this will help you realize what you can do and what you can't do, and what the questionable areas are, and the things that aren't as black and white with the cites to the cases, and it'll entertain the lawyers in the group tremendously. So I wanted to make sure, did everybody get one of those? I wanted to make sure that y'all remember me by those. So.
And we will. And we always want to keep the lawyers in the group entertained.
Yes, and they can keep you entertained. So thank you, and you want to do a group pick? Thank you, Bob. And literally, if y'all don't want to carry them on your plane trip back or whatever else, I'm not offended if you don't want to.
I don't have an excuse.
You got it, Taylor. How do you want us to work?
Let's come over here.
It's not my ball game. This is
And I guess we can all get sideways.
You want the women and the...
Opposite sides.
Oh, great. I get my skinny one.
And some over here.
Too skinny.
put Mark next to you.
Well, let's get Shannon, you can stand back there. Get on this side.
Wait a minute, I'll get over here.
I need some over here.
You know, it's a difficult group to keep together if you have that. We don't take direction.
But we can.
One more. Okay, now Shannon, can I be your replacement?
That's good, because I'm gonna learn.
You're done. Well, I'm gonna use this for our ATA news letter.
Yeah.
Thank you. You should have practiced, huh?
Parting gift.
Yep, thank you. Thank you all for that brief opportunity to appreciate service and welcome new folks. I think both of those are very important parts of our organization, and so we appreciate the opportunity to indulge in that for just a moment. I have already been recognized for having missed something on the agenda, so let me back us up to item number 2 for roll call.
Chair Jamie Rickwood,
Present.
Roy Fontana,
Present.
Mark McInnes,
Present.
Lisa Varga,
Present.
Walker Beard,
Present.
Ryan Patton,
Present.
Patrick Carlson,
Present.
Clayton Black,
Present.
and Jesse Barker.
Here.
Thank you very much. There appear to be no absences, so all board members are present. Next item on our agenda is comments from members of the public regarding non-agenda items. If you need to speak to the board regarding something that's not on the agenda, now's your opportunity. At some point, we'll ask you to fill out a public meeting comment. I'd like to remind you that those comments are limited to 3 minutes. I'd also like to remind you that the board will not be able to react or respond to the comments, but simply receive the information. The mic's now open for any public comment not related to an agenda item.
Madam Chair, members of the board, Mr. Commissioner, thank you all for this opportunity. Real quick, on behalf of the associate, my name is Bobby Crisp. I'm an AQB certified USPAP instructor. I serve this board as one of your approved mentors in the mentorship program. Got a lot of other little titles, but we'll leave it there. Currently, I'm the vice president of the Association of Texas Appraisers, and we just wanted to inform the board that our next meeting is going to be in Houston, outside of Katy, May the 30th and 31st. We'll be having a class on contracts, how to read contracts, and Saturday will be the USPAP update for those that need it. Our next meeting will probably be before the next board meeting, which will be here in Austin, and that's our annual meeting. It will be held August 1st and 2nd. Our keynote speaker on Friday will be Mr. Jim Park from the Appraisal Subcommittee. He's going to be coming down and speaking to everyone. We will have an investigator from the FBI there to talk about mortgage fraud. And then on Saturday, we will be offering a brand new course that is in the works right now to be approved, and it's called Support for Your Work File. So we're hoping that will go over well. And I just wanted to pass that along and invite each and every one of you, if you're available, you're more than welcome to come. I would like to relinquish the rest of my time to Ms. McClendon.
Thank you, Mr. Crisp, and thank you for the work that you all do out in the industry.
Good morning, Madam Chairman and fellow board, not fellow, and board members. I'm no longer one of your fellows. I'm hoping that you're not going to regret me being off the board because now there is no noose or snaffle bit or anything else that you can put in my mouth. But you can only limit the time that I speak as long as I'm speaking at least intelligently and not cussing and that sort of thing. But I did want to inform the board that I have taken some significant amount of time and looked over the complaints that Donnie Griffin with Vincent Elkins brought to your attention at the last public meeting. And I think after I've talked with a few of y'all, there's a way that we can address the procedural irregularities that took place without talking about the investigation or any merits or the substantive part of the investigation that's going on with that complaint or if it's going on. And I look forward to working with y'all in the future on being able to address some policy issues that have been raised because of that. That's the 3 minutes, unless anybody has any questions for me.
No, thank you, Ms. McClendon. Will you just go ahead and state your name into the record?
Oh, that's an important thing. Yes, Shannon K. McClendon, former board member.
Thank you, Shannon.
Just a public member now.
We appreciate your service on both sides of the microphone or the dais. Thank you very much.
Thank you, Madam Chair.
Is there any additional public comment for items that are not already posted on our agenda? Seeing none, we'll move to items 5 and 6, which are consent agenda items. Item number 5 is the ratification of the official record of the February 21st, 2014 board meeting as approved for posting on the website by the Secretary of the Board. And item number 6 are a number of approval of a number of agreed final orders and surrenders. Is there anyone that would like any item on the consent agenda removed for additional discussion?
Madam Chair, just item number 5, approved to the minutes as presented.
I'll send it.
I'm sorry, just because I need to understand. Item number 5, you have additional comment on, or you want to approve it?
I just want to approve.
Are there items on item number 6 that there's discussion on?
Well, I think we should take those separately. That's why I just want item number 5.
Okay, so let's have the consent agenda only address the ratification of the official record. Does anyone have comment as it relates to the ratification of the official record before I move it?
No question, Madam Chair.
Okay, so let's have everything off the consent agenda, and we'll deal with each item individually. Yes, sir. Mr. Barba?
Can I vote on that if I wasn't here for the last minute?
I think we'd be fine if you recused yourself from the vote since you don't know what the history was. Okay, the item before the board for action at this time is item number 5, the ratification of the official record. I have received a motion and a second for approval of that. We are now in the discussion phase. Are there any comments regarding that item? Hearing none, all in favor?
Aye.
Is anyone opposed? That motion passes unanimously. It carries us to agenda item number 6, the approval of agreed final orders and the surrenders in the matter of. Do we need to read each of those into the record?
No, it's part of the record.
Okay, so items A through N.
Madam Chair, if I could just point out that the last order, item number 6N, was provided to you on the dais, and you should have a copy of that order. We just received that from the respondent yesterday.
Yes, ma'am. Mine was present. Did everyone receive one at their seat? I'll give you just an opportunity to review that since you've received them at the last minute, and then we'll move to, if there's any particular item you want to speak to, we'll move it separately. If not, we'll look for a motion for approval of all. Oh, I'm sorry. I do have a public comment for one of those, so I apologize. There's a lot of paper up here to shuffle. Item 6B, we will need to take up separately. There's a request for public comment on it.
Madam Chair, do we move forward with the all of them except for that one?
I would say that's fine. Troy, do you need to make comment prior to 6B?
No, Madam Chair, I'm just here to answer any questions.
Okay. Are there any questions of staff? Floor is open for approval of items 6A, C through N, unless someone has additional comment on individual items.
So moved, Madam Chair, to approve as presented.
And a motion from Mr. De La Garza for approval. Is there a second?
Second.
A second from Mr. Black. We are now in discussion. Is there any discussion? If not, all in favor? For items, aye. We will take up now item 6B. Mr. Crisp has a public comment request on item 6B.
Thank you, Madam Chair. Board members, yesterday I had the opportunity to meet with this young man, Mr. Wampler, and although the agreed final order has not even been signed by this body, this young man has already taken the initiative to do everything that's already on the agreed order. He has completed everything except now the 90-day log that he's been asked to provide after 90 days. He's already taken the coursework, he's already done his mentorship, and everything else is completed. Well, there's issues behind this situation that I need the board to know about, because I don't know if you're fully aware. I know you read the dockets, you read and everything that has been presented to you prior to this public meeting. Turns out this young man had applied for licensure. Not certification, but state licensure. 2 reports were picked for the audit. One was from his 30th, my understanding, approximately his 30th day as an appraiser. The other one was a more recent report. And the second report was basically just set aside, and the complaint was a staff-initiated complaint against the appraisal that was done on this young man's first month as an appraiser. Granted, we understand that trainees have a supervisor and they are responsible for everything that goes out. We understand that. Were there mistakes made? Yes. Yesterday, I had the opportunity to spend 8 hours with this young man. I saw his recent work. I said, just go pick some. I don't want something yesterday. I want to see something that you've done in the last couple of months, maybe something 5-6 months ago. This might be one of the best appraisal reports I have ever read. And he's being penalized, if you will, because he's being now being offered a probationary license for a period of time, which he is now required to notify all of his clients that he has his probationary period, and his supervisor said that it was a death sentence because he's going to get no work, none. Once the clients find out they have a probationary license, there will be no work done. So that got me to thinking about everyone else under that situation. If they're getting these probationary licenses over this time frame, what is that doing to their livelihood? So, with all that said, after reading what I read and after spending the time with this young man and his supervisor present, I'm going to ask, and I've never done this, and I don't even know if it's appropriate, but I'm going to ask this board, this young man needs a contingent dismissal based on everything he's done, because this indeed is one of the better appraisal reports I've ever seen, and you need to know that. You need to know that this young man, when he started out, is not the same appraiser that he is today. He is a much better appraiser, and he would serve the public well. That's all I have to say. Thank you.
Are there questions of staff? Or Troy, do you have any comment?
Madam Chair, my only comment is that I didn't handle this case, Mr. Wolf did, but my understanding is that this individual negotiated out an agreement and, as far as I know, still wants to sign the agreement that will provide him with the probationary credential.
Madam Chair, is this young man still a trainee?
I'm not certain if he is or not.
But the report that you got or investigated was a 30 days into his being an appraiser?
Consistent with policy, we pick one report at the beginning of the time period on the experience log and one near the end. I don't know, Mr. Wolf might be able to explain in more detail, but I do know that we typically pick two.
I'm not certain of the Kyle Wolf, staff attorney, of the specific time, but I think it was early in his trainee period. I'd have to go pull the specific log. I don't think Mr. Chris would be wrong if he said it was the 30th appraisal on his log. So,
and so the second appraisal, the one latter, there were basically no mistakes. I mean, because they're all mistakes. But the one that was targeted more was the one that was at the beginning of
the one that was had multiple deficiencies.
Madam Chair, at this point, I'd like to go ahead and pull this item from the agenda till we receive a little bit more, study it a little bit more, and if we need to, staff can bring it back. But at this time, I'd like to pull it for more information, please.
Okay. There is a request to pull the item for no action. Is that what I understand you to be requesting, Mr. De La Garza? And the floor is open to consider that request. There were several other people reaching for mics, so I'd like to get additional input, and then we'll, unless there's a second to that, we can get into discussion and the same opportunity exists. So,
Madam Chair, I agree with Mr. De La Garza. I mean, we have an individual's life, professional life right in front of us, and if we're kind of guessing around, or maybe I don't have the file with me, I don't know, it's upstairs, I think that staff needs to go get the file, and we need to fully explore this.
okay, so we have a motion and a second to remove this from action, and we are now in the discussion stage.
Madam Chair, if I may, what can the board do with that agreed order? What can we do with that?
That may be outside my expertise because this is kind of uncharted territory for me. I would be happy to. I'd be happy to present the file. I would just have to, make sure and discuss with GC that we weren't, doing anything inappropriate. But
General Counsel, what can the board do with the agreed order that's already been signed by the respondent?
The board is free to reject the agreed order and send it back to staff for further investigation and further recommendations at a future meeting.
Okay, thank you. Also, staff, Kyle, I guess, I have, in the 3.5 years, never seen this disclosure of probationary status on a AO before. Do we use this?
It's relatively new. I believe it was approved by the legislature in September 2011. Right now, it seems like we have a flux of applications prior to the 2015 AQB changes, and on some of these, instead of going through a trial or a long protracted hearing, we have come to an agreement where we've used the probationary credential from the Act. I can't remember the specific provision.
And board members, this is Troy Bullier, staff attorney. I was just going to add that we have previously used this statutory provision, not a bunch of times because it's relatively new, but we have used it in the past few years.
Mr. Bullier, would you mind pointing out to me in the statute, I'm assuming the 153.24, where is this referred to in that particular
Well,
reference?
if you look at page 3 of the order, which is page 31 in the materials, if you look there, bullet number 5 that says disclosure of probationary status, it makes a reference to the actual statutory provision, which is in the occupations code, 1103.2091C.
So that is not in our matrix then? That's
I believe,
not part of our matrix.
No, that's part of the statute. I do believe, though, there is a corresponding board rule that addresses it as well.
I think that's what I'm asking. Where's that referred to?
Hi, Mark Murnick, Enforcement Director. I think what the confusion is this is an application, and so it's not part of the 153.24, the disciplinary matrix. So this person has applied from going from licensure to certification, and so in accordance with policy statement, I think 4 and AQB standards, we have to determine if the work submitted generally conforms to USPAP. We are to pick at least 2 samples of work, one from a prior period and a latter period, and we're not, all that work submitted, if they're claiming experience for that, it has to conform to USPAP. So whether it be the first one they did or whether it be the last one they did. So that's the standard that we, through the AQB and through the ASC, are required to ensure. That's what we do when we audit. So
I understand that, Mr. Murnick. I'm talking about our use of this.
Yep. And so
I haven't seen that before.
Yeah, so Troy had referenced that we have used it before. So in lieu, or as opposed to denying somebody and having them request a hearing and going through that process, this is a way for us to work with somebody that has submitted work that does not generally conform to USPAP to say, okay, we want to work with you to get you approved to get out and start working, so we'll give you a probationary approval that you do X, Y, and Z, and then we'll re-audit new work samples that you submit, and if that is fully, generally conforming to USPAP as the standard is, then you come off of your probationary approval and move forward with your full credential. So, the probationary approval is for a certain period, whatever, I'm not sure, whatever this one is, 6 months or a year. It's like the, in the dismissal realm, it's like a contingent dismissal, but it's for the application realm that you do X, Y, and Z. We won't deny your application. We will approve you on a probationary status.
Thank you. I think where I'm still getting stuck is maybe in the disclosure part. I understand the probationary status, and I'm fine with that, but why are we asking this applicant now to disclose this in all of his work? I've never seen that. It is required for disclosure?
Yes, ma'am.
Okay.
It's required in the 11.
That code requires that he discloses it?
It has to disclose it to all clients, yes, how the legislature wrote it.
Okay. All right, thank you, Madam Chair.
Yeah, thank you for clarifying too, Mark, too. Just so there's no confusion, this is not a disciplinary action. This is for Mr. Wampler to basically not have an outright denial of his application. If that is what an ALJ recommended, this was kind of an intermediary step that he could have a probationary license. It sounds like he had finished everything, just to clarify some of the terms that the agreement we came to. And what we wanted to see was just 3 months more work product, which it sounds like Mr. Crisp is representing that his work product's really good. If once we get that 3 months, we would remove the probationary tag on his license and he would have a full credential. So this was kind of to avoid, just having an outright denial, basically.
Is there a standard for 90 days versus 30 days versus 6 months in terms of period of time that you want to look at his work?
Typically, what I've seen and what we've done is in increments of 3 months. It's just the type of procedure we follow. But there's no standard of how much experience we need to review. No, ma'am.
And does the ASC require us to pick something from the beginning of their experience as well as from the end, or is that something that we've just routinely been doing as a practice?
Sure. The ASC is very broad. They say all experience must generally conform to USPAP. What we do is typically try to get a good representative, take something near the beginning and near the end, and we take a holistic approach at looking at both of those.
And while I appreciate the explanation and understand that if they're getting credit for the work, it does need to conform to USPAP, I do have a heart for the fact that I can guarantee you any of our quality of work in our careers is better more towards the end. And so it's interesting in terms of the process that we have to use in order to give the approvals. We have a motion and a second, and the floor is still open for additional discussion or questions. If there are none, then we will vote. All those in favor of removing item 6B from any action at all for future consideration, say aye. Oh, I'm sorry. Go ahead.
Madam Chair, I just was reading this closer, and this individual has completed all the courses and has passed the exam. Is that correct? And this individual's just applying for state certification or licensing. Is that right?
Yes, a state license, and he has done everything up to what we received the experience portion, and that was the part where we found deficiencies. And what we said is we will basically overlook that, and you can do remedial education and be issued a probationary license.
My only concern is, and I agree with pulling it, I would like to talk about it. I do not want to put this individual in a worse place than they would be if we accepted this order. If the requirement is that this board take the next action, I just simply want to remind you, we are 90 days from another meeting. And so I suppose we're now making decisions for this gentleman's life that I wish he were in the room for us to decide whether it's more beneficial to him to not have this action or less beneficial.
That was my concern, Madam Chair, as well as I started reading the facts a little bit closer. And that is, as we all know, all the requirements for licensing certification changes after January 1st of 2015, and I was concerned that we may be putting him in an onerous position.
There is a question at the dais, must we vote on the motion that's on the floor? No, that motion can be withdrawn if that is the desire, or we may vote for the action either way.
And if we vote no on the action, it kills the thing, and the gentleman gets his license and continues?
Well, no, we require, I believe, an additional step of approval of the final agreed order.
If I can reframe a motion to exclude item 5 from his agreed order.
Okay, now maybe we should.
Per general counsel, is that correct?
Yes, the board can make changes to the agreed order.
So maybe for clarity of the record, since there is some conversation about potentially desiring to do something other than wait for 90 days, yes, ma'am, I'm going to give you the opportunity. We might want to consider doing something different with the motion that's on the floor. Kristen?
My intent is, I think this whole thing this whole agreed order was far ahead of what it should be, and I don't want this young man being penalized in any way, shape, or form, and that's what I'm trying to do, is remove this so with no action he continues.
I don't know that that is true, though, so that's what I want to give you clarity on, Mr. De La Garza, is I don't believe the removal of the action will put the gentleman in a better position. I think it simply puts him in a hold pattern until such time this board can take action at some future date. So we may very well want to explore what the options are to actually take some type of action today as opposed to delaying an action. And our general counsel would like to make comments, so Ms. Worman.
Yes, with respect to the vice chair's request to simply remove item 5, my response was that the board could make changes to the agreed order. However, if you can't simply remove item 5 because that is a statutory requirement if you are accepting item 1, which is to issue him a probationary license. The statute does require the applicant to disclose that he has only a probationary license. It might be possible if you wanted to delay consideration of this item until a later point in the meeting to allow staff to review the work file and bring more information to you. That would be a possibility.
Can we shorten the length of time of his probationary status?
You could.
So that might be an option. One of the concerns is the period of time, and I've got to tell, and I understand 3-month increments. I also understand 90 days with no income is tough to overcome. Oftentimes, people can find a way to bridge a gap for 30. And so if, in fact, the work product did, and let me ask you, did you find his second appraisal to be of quality? It was simply the first one that was reviewed that was of issue?
It generally conformed, yes.
Okay. So that matches Mr. Crisp's
Madam Chair,
testimony, if you will, that his work is improving. Yes, sir.
could we change the probationary period to today, up through today? And that way we finish with the, could we change the probationary period that he's already completed his probationary period as of today? He's already completed his work, he's turned in the logs, he's done his mentoring. So
I don't know the answer, but I'm sure someone in this room does, so I will direct it to someone that knows the technical answer.
Yes, Madam Chair, you could change the term of the probationary license to be effectively completed as of the date the board approves his order today.
Okay.
I'd like to go ahead and amend then, that we go ahead and if that's okay, Mark.
Could we potentially withdraw the motion that's on the floor?
Yes.
Because it's going to get incredibly confusing to try and
Okay.
Mr.
So
Beard,
I'll withdraw my motion and start a new motion.
Okay. Mr. Beard, are you okay with that? I believe you seconded that original motion, or I'm sorry, Mark, are you all right with that? Okay, so there is no consideration for the motion that was on the floor. There is a attempt to restyle the motion. Mr. De La Garza?
Yes, to go ahead and concur with staff on their recommendations of what has happened here and change the probationary period effective the time served up through today, and the everything that's already happened and been submitted, accepted, and do away with the probationary period.
Yeah, I have one more question. The other items have all been completed? All the requests for everything else has been submitted and completed and conformed to?
That's been reported to us. I'm not sure it's been turned into us.
I have not received anything. We haven't received anything, but Mr. Crisp is saying that it's done. I'm sure that's happened. It's just sometimes they'll wait till the very end if Bobby just completed it. That would be one concern, that if he is like a time served or just a one day, that maybe he hadn't finished it and we don't receive it. But I don't know.
Thank you. Mr. De La Garza, just for clarification to answer, yes, I did see the certificate of his education he's already taken. That was a requirement of the agreed order, and we just completed the mentorship yesterday afternoon. So we have not had time to submit anything. And again, he wanted to wait till it was formally signed and make sure everything was signed by the chair and before he submitted that paperwork. But it all has been completed, yes, sir.
Thank you, Bobby.
Mr. De La Garza, I might recommend that you consider making whatever conditions you're thinking about changing contingent upon the board or the organization actually receiving those items that have been reported to us that are completed.
That was the second part of the motion.
I would also ask that if the goal here is to eliminate the probationary status or consider it time served, is there a need to change the experience log requirement? Is that it seems to me those are tied together. There's the reason we're requiring an experience log is to deal with the probationary status and continue to review his work. If your desire is to take the information you've received today and indicate that we believe the work is quality enough to remove those requirements, you might consider whether that change needs to be made as well.
And I think the young man and the mentor have complied with the quality of work that needs to be done. So the experience log from here on is also part of the motion to they don't need to continue with that. Everything has been complied with.
Madam Chair,
Yes, ma'am.
it might be cleaner if that is the intent of the board to simply accept the agreed order with the removal of items 1, 4, and 5, subject to a demonstration that items 2 and 3 have been completed.
Thank you very much. We
Thank
needed
you,
that
Counsel.
assistance in cleaning things up.
That's my motion.
Well done.
There is a motion. Is there a second?
I'll second it.
I have a question of staff. Does that, do you believe that addresses all the outstanding issues hearing the board's concerns?
Could we hear that motion again, please, Madam?
Yes, it would be, believe, if I can restate it, the removal, boy, I'm sorry, I didn't write it down. So, Kristen, can you restate it again for us?
Certainly. It would be a motion to accept the agreed order, but delete items 1, the probationary license, 4
and 5,
and issue the license subject to evidence that the applicant has completed items 2 and 3.
I thought you said we couldn't sign the agreed order, or the chair couldn't sign the agreed order and leave out 5.
If the
Well,
if
we're
number 1 goes
removing
away?
item 1, so he would be issued a license subject to a demonstration that he has completed the mentorship and the education.
I'm quite, doing such, I think it changes the nature of the agreement entirely, that it's not a probationary approval, so.
That's my purpose.
And I understand that's your purpose, Mr. Garza, and thank you. But so when, in terms of what we can either deny an application because it doesn't conform to USPAP, or under the other option we can do is do a probationary approval. So if we remove that, I'm not quite certain what action the board is really taking in this regard in terms of when we get audited on this report. So did you have something more that you wanted to say?
Madam Chair, can I respond to that?
Yes, go ahead, Mr. De La Garza.
I'd like to just make clear my point is that the appraisal or the report that was looked at, he was in 30 days 30 days into his doing it as a trainee. While you are correct that all reports should follow USPAP, I don't disagree, but I think he's still a trainee and still under the mentor that is helping him do that. So that my thinking is, let's not, as it is, the industry is already knocking us back and forth with reports and adding, excuse me, and adding more and more to what we need to do. We don't need to add more burden to the appraisers today, and that's the reason for my motion.
Okay, and I appreciate what your aim is in doing that, Mr. Garza and De La Garza, and I don't know what the understanding is, but I don't have a agenda to make it more difficult for somebody. The standard is on the AQB that whatever hours they submit for approval have to conform to USPAP. So that's what we're held to. And my goal when I come in the office every day is to ensure that we're doing what we're doing so we pass these audits when they come up every 2 years. So it's not to make the appraisal world more difficult for people. But so when we look at doing the audits, in terms of what I understand, we have we can either approve we can deny, or we could do the probationary approval. So if we take away just the whole probationary aspect of approval, I guess then what the board would be doing is just a flat-out approval, I guess.
Why
And,
do you
and I
think
think we're
that
just
the-
looking at this one case. We're not looking in general, we're looking at this
But
one
I just,
particular
I
case.
want to ensure that, you know, whatever we do, it passes the audit, you know, in 2 years.
But
And I think,
would,
I'm sorry, go ahead.
I would agree that I think in essence, we are saying that we would like to go ahead and approve his application for the license.
Did you have anything legal?
Can I jump in? Because I've had a question that I've let. So why do you interpret the actions that we required him to take to not have some aspect of probationary issue in them? In other words, it's not as if we said, gosh, the stuff arrived, wow, it didn't match USPAP, and so therefore we're going to issue the license anyway. The way I hear it, even if you remove some of this discipline, there's still been additional steps required. You don't think that will pass the audit muster?
Well, we can do the approval, we can do the denial, we can do a probationary approval. Within the time in which the application is open, we can, and we have before, require somebody to submit additional work to review, or we could say if you do X, Y, Z within that time period, we can, you know, possibly still approve your license. So I guess it could be like a conditional review of additional requirements before approval.
So if we put him on probation for a day, would it meet your probationary approval?
I agree. I think
I'd like there to be some consistency. I appreciate the concern that you're raising. I'd like to be able to say to the ASC, you stayed within whatever guidelines you felt like you needed to do as well. How can we accomplish that, hearing the board's concern and desire?
We've done conditional approvals before, right? We could do something like that, like contingent approval or something. We have before on a couple instances where somebody's really close to being approved, do something like, you know, our contingent dismissal, do like a contingent approval where we say, okay, this application is open for a year. We reviewed this information that you submitted, experience within 6 months. Within the next 6 months, do so many more hours, we'll review out of that and do X, Y, and Z courses. So we could, in essence, do that with this person, but it would not be a probationary approval, because if you remove, I think, paragraph 1, and that takes out the whole probationary aspect of it. So it'd be like a contingent approval or conditional approval.
Can you leave the probationary language in and shorten the time frame to a day?
Yeah, I think you can, because I don't think the statute requires any particular time frame. I don't have the statute in front of me. I would refer to Kristen, Ms. Horman on that. But I don't believe there's a particular term that's required for probation. So yeah, I guess you could put it to one day.
Would that then solve your problem?
Yes, it would. The only thing on the experience logs, what we're going to do with that was just to sample more work to ensure that's up to, but I'm sure he's been doing extra work, or he's been working in this time period since this, so we could ask him to submit a log and out of whatever he's done from then to today, if today's the one day. So yeah, I think that could, I think 1 day would probably satisfy the probationary term.
General Counsel, because you've been helping us with this, and we appreciate it very much, if that was the desire of the board, we would need to alter the way the motion is currently on the floor, as I understand it.
Yes, that's correct. Rather than deleting items 1, 4, and 5, you would leave those items in and simply change the term of the probation in item 4. So the probationary period would be limited to 1 day. You could make it effective as of tomorrow, because the 1 day being today.
Yeah, the language on the experience log will also need to be corrected as well. So obviously, General Counsel is only helping what she believes she hears, so I will need someone to articulate the board's desire at some point.
Do we need to withdraw the existing motion so we can start a new motion?
Or amend it, either.
Well, I would, just withdraw it and start new, if that.
Very fine. So we'll have our second withdrawal.
Because we definitely want to comply with staff and what we need to do. So And I think this is what we need to do is change it to a 1-day probationary and change the language on number 4 to reflect a 1-day probationary period.
And Madam Chair, if I could just make one, you had asked earlier if there was any other items of concern that we noted, and one thing that I did note, it may be more of a technicality, but since this is a consent agreement, we obviously don't have Mr. Wampler here. I know in the past when the board has made changes to an order and the party has not been here, that you've asked staff to simply go back and have the other party ratify that. So if changes are made to this order, that would be my suggestion, is that you direct staff to go back and ensure that Mr. Wampler agrees with all the changes. I'm sure he would, but just
My
pointing that out.
intention would be to ask you to probably try and reach out to him sooner rather than later. Commissioner, do you have any suggestions based on all that you're hearing?
Certainly, Madam Chair. I think there's perhaps one simpler way to deal with the apparent discrepancy between the perception that the issuance of probationary license, just that status, is somehow an inordinate burden or a black mark on a record that would affect the career of this individual much longer than really we anticipate. It's certainly not our intent to do that, but if that's the perceived outcome, then I might suggest that the board consider simply rejecting this agreed order and directing staff to review additional reports to validate, if you will, the representation that the majority of the claimed experience is generally USPAP compliant. So, we got one that was generally not, and so we have to take action based on that. We have, as was suggested before, kind of left the application open, reviewed additional reports, been satisfied that in fact the majority of the experience meets USPAP requirements, and then issued a license without ever having to deal with the probationary issue. That's just a suggestion.
Madam Chair, my question, Mr. Olnixon, would be, what would happen to the work that's already been done, the mentorship and all that extra work?
I'm sure he benefited from it.
Okay.
Madam Chair, if I may.
Yes, ma'am.
Thank you, Commissioner, for your clarification there. I would like to go ahead and put to the board that I think that the commissioners thought theirs already been satisfied through staff. They already have reviewed some of these other work products of this appraiser. They said that they reviewed another appraisal. So
that's correct. We did pull it, and it's a minimum requirement of the AQB that we pull 2 reports. So one was found to be generally compliant, one had issues, and that's what's led to this order. So my suggestion was that the board direct the staff to go back and review other reports, and if we find another or 2, whatever, was directed are generally compliant, then approve and issue the license without ever dealing with the rest of these potentially negative consequences.
I appreciate that. I think the goal was to remove the probationary status ever from the gentleman's record. Mr. Crisp, do you have a comment?
One additional note, and I really was wanting to kind of keep this under the belt. The appraiser in question that we're talking about, the young trainee we're talking about, he shared with me a lot more information than I have shared here. One of the things that he did share is once he hadn't heard from enforcement whether he had been approved or not, over a 2-month period he called to find out his status. And they said, oh, you've been denied. And as a matter of fact, we filed a complaint against you. So this was his first notification, was via a telephone call. When he found out what the complaint was about, being the report in his first month of being a trainee, he said, did y'all look at the other one too? And he replied, yes. And then he said, can I offer additional reports? I live here in Austin. I'll drive them over to you. I'll give them to you. Can you please look at other work I've done? The response was, we don't have enough time for that. Now, this is hearsay from me to you, but I'm replying what was told to me yesterday afternoon.
Okay, appreciate the additional input. Let's, hopefully, let's stay focused on the...
Madam Chair, if I could?
Yes, sir.
And although I appreciate Mr. Crisp's allegations and statements, this is repeated fodder from Mr. Crisp, and staff has passed numerous audits and has cut mustard numerous times, and I just, we can't, the board can't accept a non-signed complaint. So if we're going to have these allegations coming up here, mudslinging on these, it's not appropriate, it's not professional, and I, for one, don't appreciate it, of these repeated abuses and allegations made against staff.
Thank you.
I will say that's categorically untrue, too, that I never said that to Mr. Wampler.
Okay, thank you.
First of all, with regard to Mr. Murnak's comments, that was not my intent to be throwing mud. As I stated before I came up here, that was something I didn't even want to share. But based on the conversation of going on with the board here, I thought that that was something that you needed to know. No, it was not Mr. Wolf that said that. It was not Mr. Murnak said it. It was none of the attorneys. It was someone else that said this to him, according to Mr. Wampler. And again, the only reason I brought it up was to let you know, and I understand it's hearsay. I get that. But again, there's things going on that are not on the up and up, and these people are representing you, this board, and you need to know about it.
And we appreciate that, Mr. Crisp. I hope you understand that we've had that as a laser focus in this organization for at least the last 12 or 18 months, and I believe that we've made great forward progress. I'm disappointed to hear any additional public comment about it, but of course, if it exists, even if people are just simply talking about it, we need to address how that affects the organization in the long run. So while I hate that it has to happen in this setting, I understand what your comments are. Board, I do believe we are trying to make some forward progress as it relates to Mr. Wampler, and I would ask that we refocus on that particular issue. His agreed order is before the board for action. There's been a number of different variations on how you'd like to handle his agreed order. I suppose that the floor is open really while we've had some general discussions about the way a motion might look. I feel a need to ask someone to restate what the desire of the board is so we can go back to another opportunity for discussion.
I have one more question, just for clarification. The person's had a complaint filed against him. That's on the record, right? I mean,
Staff's initiated.
this, well, I mean, this,
It's still a complaint.
it's a complaint is a complaint. It's on his record already, correct or wrong?
And I'm only basing on what I'm reading, so I guess, Mr. Wolf, can you answer that question?
The appraisal that was found deficient, we initiated a staff complaint out of that.
Okay,
yes.
so.
So is the answer-
So he's got, if somebody said in a year, have you ever had a complaint filed against you? The answer is yes. Regardless of what we do today, it's still yes, correct? Whether we do the whether we put probation down to 1 month, or if we withdraw it and you reconsider it, it's still on his record, is that
Correct. The complaint will be on his record, but to keep them separate, they are separate matters. I know it's a little bit confusing, so the probationary would only apply to his credential and would be non-disciplinary in nature, if that makes sense.
Okay.
So,
Okay, so as far as his record is concerned, what is the less derogatory? I'm not using the right word, but if he was going to submit his credentials to a potential client, which would look the best on his record? The 1 day of probation, or withdrawing it and reconsidering it?
Well, Mr. Walker, I'd caution you. I don't know that you can turned the ship around. The complaint is there and it's on a record. If you're asking, is there some way to remove that, that's a whole different conversation than what we've been doing. But
Well, I
go
thought
ahead,
that-
staff, and answer.
I thought the commissioner just said we could withdraw
Withdraw the complaint?
this agreed order and reconsider it.
Those are two different things. That's
Correct.
Okay.
They are two different things. So the suggestion was simply to deny the order and ask staff to review, ask for additional logs and review additional work, and then redetermine whether or not it is general use PAP compliant and whether the application should be approved. Okay, we can't undo what's happened already.
Okay. So it's there. So what my question is, following that course of action versus what we're saying today to lower his probationary period to 1 day, what's the most desirable of those two for the appraiser's perspective?
Excuse me, Madam Chair, if I may. Can I go ahead and try to style a motion that I think is going to hit on Mr. De La Garza's points and Mr. Beard's?
Certainly, and Mr. Beard, keep in mind, we'll be in a discussion stage in a moment, so
Okay.
we're not keeping you from talking. Go ahead.
So I'd like
Ms.
to move
Fontana.
that we move forward on staff's recommendation to accept this agreed order with the omission of, changing the probationary status date to 1 day from today, and also changing the experience log date where it cites on or before February the 9th to tomorrow also, or next business day. And I believe that will satisfy us moving forward on this case, so this appraiser does not have to go through any more of this process. And I believe it will satisfy staff's audit needs.
We have a motion. Is there a second?
Second.
We have a motion and a second. Now, the floor is open for additional discussion. Mr. Walker, I think there's still some confusion about the combination of the two things, I believe. And if I am misstating, because certain, go ahead, Kyle.
Yes, Mr. Walker, if this is approved, I will reach out to Mr. Wampler right now and ensure that he ratifies it. And I have discussed several alternatives, and he chose this. This will just be a reduction of this. I can't speculate for him, but I imagine that he will not have a problem with this. But I will reach out to him after this if it is approved. So,
Great.
Does that address your concerns, Mr.
Yep.
Beard? So there's a motion and a second. Any additional discussion?
Yes, Madam Chair. The issuance of a probationary license, as the order is styled today, the contingency for the end of that is a successful review of additional work. Okay, that's the way that paragraph, doesn't matter what date you put in there, it's still contingent upon the successful review of additional work. The additional work could be work that was done yesterday that he delivers tomorrow. I get that part. Okay, but it's still contingent, lifting the probationary status the way the order is written and envisioned, is that then that satisfactory review would lift his probationary status. So that's a little bit inconsistent with the stated intent of having a 1-day probationary period.
So maybe there should be some clarity to the motion. I expect, based on the conversation at the dais, that there is an expectation that he's going to have to submit an experience log. My expectation is that experience log would have been from whenever the start date of this issue first came about through tomorrow, is what I heard. So I think the intent is to try and address exactly that concern. So the opportunity for us as an organization to continue to audit additional work, I believe exists, Commissioner, unless you see something differently there.
Well, if it is simply the delivery of the log, that can be satisfied. Okay? If that is the intent of the board, that the gentleman deliver a log and that ends his probationary period, that's fine. Without any review of the work. The typical, what we do the purpose of requiring a log is to get an additional body of work to review, typically. Now, whether or not that is included in this order as the proposed amendment, I'll leave that to the lawyers to figure out.
What part of the proposed amendment that's been removed or adjusted do you believe eliminates that requirement? Because I didn't hear anything other than alteration of language that pre-exists. So is the concern that you have already typed in the order? So the log I see, requirement to submit it, the assumption that you're going to be looking at it pre-exists. Is there something that Ms. Fontana's motion removed from the order that now makes you concerned that we have eliminated an additional requirement?
No, my point was that I believe that this order anticipates, and gentlemen, Mark, I would ask you to clarify this. In just reading through the order itself, it appears that there is not language that the mere delivery of the log will be the final satisfactory conclusion of all conditions under the order, regardless of and does not anticipate review of any additional reports to determine if they're generally USPAP compliant. If I'm reading that correctly, then I believe Ms. Fontana's motion satisfies, if that's the board's intent, that delivery of the log lifts the probationary status. That in and of itself, regardless of the quality of the work.
Mr. Commissioner, Mark Murdock, Enforcement Director, I believe you're correct in reading that provision. I don't receive a requirement that as a condition precedent to the respondent coming off probationary status be that staff review additional work product and approve such. I just see that it's a requirement that he submit the log, so he submit the log with work product that he should have to date. He'd be good to go, and that status would be lifted. So I think the motion would be fine.
Okay. Very fine. So we have a motion. Second, any additional discussion or questions? All in favor?
Aye.
Is there anyone opposed? Motion passes unanimously. That was a lot of heavy lifting. Thank you for the hard work. Takes us to agenda item number 7, which is executive session. Do we need an executive session?
Madam Chair, I believe we were going to have a brief executive session.
Okay. So the time is now 11:20. The board will now go into executive session to obtain advice of legal counsel or discuss pending or contemplated litigation, including settlement offers and enforcement actions pursuant to the Texas Government Code 551.071. We anticipate returning to open session in 30 minutes. In 30 minutes. Yes.
Environmental engineering.
The time is now 12 o'clock, and since we have an assemblage of the majority of the board present in the room, we will go ahead and resume our agenda. We are returning from an executive session with no action to be taken from that meeting. Agenda item number 8 is the report by the AMC Advisory Committee, but before we actually move there, while we give Mr. Barba an opportunity to return to the dais, we are on item number 8 of 20 some odd items, 27 or so. Is it the desire of the board to take a lunch break or to work through?
I'm fine with working through.
Thank you, Mr. Black. Work. Okay, I see 1, 2, 3 work, 4 work, 5 work, 6 work.
Agreed.
Agreed. Okay, very fine. So just wanted the public to be familiar with what we might be planning on doing. We are going to forge ahead. We are on agenda item number 8. That is the report by the AMC Advisory Committee. That committee is made up of Ms. Fontana, Sarah Oates, and Lawrence McNamara that serve our board as an AMC Advisory Committee. Ms. Fontana, will you give the report?
Yes, ma'am. The AMC Advisory Committee met together on, I'm sorry, when did we meet? April 16th. The committee members, as stated, staff, and we had one public person there for a little bit. No action was really taken at the meeting. However, the committee did ask staff to start drafting comments regarding the proposed federal regulations that are coming down. And there are several things, thank you. There are several things that noted down the AMC complaints that will start trickling through and that we already have had. So we're going to start building some matrix on that, looking at reasonable and customary fees, some education programs. A big item, it appears to be in the federal regulation of how to handle audits, and also the AMC panel is a real hot topic. So if there's anybody out there in the public that has any interest in the AMC regulations and what the committee's doing, please, we would invite your participation in those committee meetings. They will be posted in a timely fashion, and just to let you know, our next one will be held by teleconference on May the 22nd at 10 a.m. Thank you.
Thank you for that report. Next item on our agenda is a report by the Budget Committee. That particular committee is chaired by Mr. Walker Beard.
Yes, the Budget Committee met this morning at 8:30 here in the building, and the other board members present were Patrick Carlson and Brian Padden, along with staff. We were briefed on the budget. As you all recall, we were provided a policy for budget, and the commissioner did pass that out as a separate item. You should have that in your possession with you, that sets out a very specific timeline. This is the time we propose the budget, and then between now and August, if you have any questions or requests for clarification, that's the time to address that either to the Budget Committee or directly to the commissioner. We went through the budget in some detail, along with a background on self-directed, semi-independent, and our sharing of or allocation between TREC and TALC with the board, with the committee. And bottom line is, I think we all got clarification on that again, and that it would appear the commissioner will be going through this in more detail later in the meeting for a complete presentation, but we're actually just a little ahead of where we anticipated being in the bottom line. We're not running a negative balance, so that part's positive. And as I say, the commissioner will be going over this in some detail later.
Thank you for staff and commissioner and committee for keeping us in the black. I think that is our expectation. So, thanks for the report, Mr. Beard. The next item on the agenda is report from the Enforcement Committee. That committee is supported by Ms. Fontana, Mark McAnally, and Jesse Barba. Ms. Fontana, will you be giving that report?
Yes, ma'am.
Thank you.
Again, the Enforcement Committee met on February the 16th here in Austin. The members of that Enforcement Committee that are on the board are Mark McAnally. I'm sorry, April, thank you. Mark McAnally and Jesse Barber. And I really would like to extend a huge thank you to those new Enforcement Committee members, because this committee was established several years ago and has had these same 3 people on it until recently. So thank y'all very much. And Jesse, thank you very much for showing up for committee meeting before you even came to your first full board meeting. I appreciate your input in that meeting. I'd also like to acknowledge staff and thank y'all very much for always coming in and giving us not only great input, but great direction on how it is that we're going to go forward with enforcement. So thank you very much. And also public attendance, Bobby Crisp of ATA, and also Jim Waller of FACT. I will continue, but I cannot stop telling y'all how much we appreciate your attendance at those committee meetings and how much we rely on you, not only for input from the industry to us, but also to carry the information given at those meetings out to the public. So thank y'all both very much. Not to go over any of the details in the report, as it is on the website and in your materials. I will be covering some items in specific and later on in the agenda, but I did want to thank y'all all very much for your attendance.
Thank you. The next item is item number 11, the report by the Executive Committee. Your Executive Committee is chaired by myself. I am assisted by Ms. Fontana and Mr. McAnally. Since I have such a great opportunity repetitively in these meetings to speak, I've asked Mr. McAnally to provide the report today.
Thank you, Madam Chair. The Executive Committee, subsequent to our February meeting date, the board meeting date, we met twice. We met on March the 11th, and we also met on April the 16th to cover a variety or a host of issues that both the board had asked us to take in and consider and report back to the board. There's a couple of matters that the board asked the Executive Committee to research and make a decision forward, a possible outcome or a question that had come up before the full board in previous meetings. And the first one that we considered that you all asked us to make a decision on was there was a question about as a board or as an agency for us to provide a copy of USPAP to all the appraisers. Well, staff did an excellent job in doing the research on this, but we found that at the cheapest rate we could, plus considering the number of licensing and certified appraisers, that would cost additional cost to our budget of $180,000, which we had not budgeted for. However, we did recognize that USPAP is available on the TALCB website for free, and there's many professional organizations that when you enroll into a USPAP update, you are provided a new, the most current USPAP at that time. So we felt like that the industry and the profession had that well covered, and that we decided that we would just settle with just continuing keeping USPAP on the website and making it available for not only the appraisers but for the public for free.
And so we'll be making those recommendations for entire board approval later in the agenda.
Yes, and that's what I was exactly. You will be seeing some of these matters on your agenda. For example, we looked at making some amendments and changes to Chapter 153 of the Administrative Code. You're going to be reviewing some of those later on in this meeting here. The committee recommends to the board, and this is on agenda item, a memoranda regarding a 1/2 day training workshop. You remember we did this last year, and all the board members, not only just the new board members, but the current the experienced or more seasoned board members got a lot out of that. So we're going to continue with that process. Another thing that they that was asked of the Executive Committee, and this is something that we are recommending, and that is the practice of regarding posting of committee meetings. And we decided that we would continue to, or I should say continue the board practice of posting committee meetings on the website but not in the Texas Register. This allows us to retain our flexibility to hold committee meetings via teleconference. While this will allow us to reduce or keep our travel costs down, it increases our flexibility, and I think if I remember right from our attorneys, the Open Meetings Act does not completely address this, or is it I forget which part of the statute was just a little bit unclear about teleconferencing, so we decided to just keep it as posted to the website. We also have, and this is something that will be for future Executive Committee meeting agenda items that we will be addressing. Staff has presented to the Executive Committee all the policies and procedures that the board has for a review. The committee decided at the April meeting that we would take those matters up over the summer months. Another matter that the Executive Committee also considered was the current practice of allowing a single board member to request items to be placed on the agenda and recommends that what we do is we enhance that process by using the Roberts Rule of Order. We feel like it's very important that all board members have access or the ability to request putting topics on an agenda item. But what we're also doing is what we're also doing is asking for the chair to be part of that process so that there's clear communication and flow through, that the exact matter that a board member wanted actually got in on the agenda in the same and full intent as what the request would be. So that's going to be a slight differentiation than what we've had in the past. We also had, and we looked and discussed and reviewed the consent agenda items that we've already practiced this morning. It works very efficiently, so we, as executive committee, recommend that we continue using consent agenda items when we can pick multiple agenda items up in bulk and look at them and decide at one time. We were briefed by our general counsel, both from the Attorney General's office and by our staff Attorney General, on the use of executive session, and I think that we all came out of that session with a clear understanding about the executive session and use thereof. I mentioned earlier about the executive committee will be reviewing the policies and procedures over the summer months, and also what we're going to do is also Ms. Fontana has volunteered, and this is be a going forward process too, is adopting a policy for board recognition of outgoing board members. And that concludes my report, Madam Chair.
Thank you.
Madam
Kristen?
Chair, I just wanted to point out that both the enforcement and the executive committees met in addition on April 29th, and those supplemental reports were provided to you on the dais when you came in this morning, and they were also posted on the website with the other board materials.
Appreciate the clarity. As you can tell from the executive committee report and the length of that report, there was a huge volume of work that was assigned to the executive committee at the last board meeting. So I'd like to express my personal appreciation to the two folks that signed on to that committee for the unusual volume of time that we needed from you in this period of time, and to the staff for the unusual amount of extra work we needed for you to complete for us to be able to make good recommendations to the board as we move forward. So I do very much appreciate all of the hard work. That takes us to agenda item number 12, staff reports by the Commissioner and division directors.
Afternoon, Madam Chair and members of the board. Thank you, as always, for your continued service and commitment to the success of this body. Welcome to Mr. Barba and Mr. Padden. We look forward to your contributions to our ongoing mission of public protection and service to our license holders. And we thank Ms. McClendon and Mr. Kidd for their past service on this board. Well, we've all been very busy since our last board meeting. We've responded to the Appraisal Subcommittee's preliminary audit report and authorized the payment of $8,500 in bonuses to the agency staff who met the criteria that we put in place last August because of the success from the ASC audit. That was the contingency. So at this time, there are no performance-based incentive compensation programs in place for the staff, and none are anticipated for next year in the budget. We completed the strategic planning listening tour and began our evaluation of the results. Many thanks to those who took the time to participate or answered our survey on the website. We had more than 100 participants, and I'll talk more about that, about the plan when it comes up on the agenda. As you heard, the Executive Enforcement, AMC, and Budget Committees have all met, some more than once, and given staff a list of topics to research, report on, and in some cases help to shape your policy deliberations with specific recommendations. And we very much appreciate the confidence board members have expressed in our professional support to you. We continue to make progress on the quadrennial rule review, and there are several items on your agenda to move that process forward. It is always good policy when you clarify and clean up our rules to make them more effective and understandable. We also continue advancing the construction of our new website and expect to either have it launched prior to our next meeting, or at the very least have a full demonstration for you at the August meeting in preparation for a launch, certainly not later than 1 September. Christine Anderson, our public affairs specialist, her unexpected 6-week early delivery of her baby boy on April the 13th prompted a reshuffling of responsibilities, and that's introduced some new variables in our timeline on the website. So the good news is that baby Jackson and parents are all doing just fine. And Christine should be back with us in August. Your general counsel, the enforcement director, and I attended the Aero Spring Conference, and Ms. Warman also attended the AQB meeting immediately preceding that conference. Implementation of the 2015 AQB criteria was the major topic of the meetings of the conference, and I can inform you that the fingerprint-based criminal background check implementation has been delayed to January 1 of 2017. That does not change the necessity of addressing the legislative changes needed here in Texas in 2015 to enact the program. But it does give the agency a little more flexibility in timing the effective date of the program. And lastly, I want to give you a brief update on the matter that was raised in the public comment period at your February meeting. I am in communication with the Speaker, Mr. Griffin, and will conduct a thorough investigation of any specific allegations of inappropriate conduct by any board staff and update you continuously on this matter as it develops. It has been another very busy quarter, and we see the same ahead as we continue to implement the policies that you set for us. I'm happy to answer any questions that you have for me. Otherwise, I will turn it over to division directors for a brief presentation of their regular reports included in your meeting materials. Any questions for me? All right, then. Thank you.
Yes, sir. Thank you for the report.
Good afternoon. Lori Deanda, Director of Reception and Communication Services. Please refer to the C1 report. For the month of March, we received a total of 15,816 calls, bringing the fiscal year-to-date total to 111,960. We assisted 377 walk-ins, bringing the fiscal year-to-date total to 2,925. We responded to 5,368 emails, bringing the fiscal year-to-date total to 34,732. And I'm also pleased to report that we've maintained the 2 business day response time. And I'm available to answer any questions. Thank you.
If I might just add one thing to Ms. Deanda's report. I actually have authorized as a management tool the addition of one person to her staff on a go-forward basis. We have 14 phone lines, and so she will now have, so that she can manage full-time, she'll now have 14 persons answering phones. So that's just, you know, as we look at the average hold time and things like that, it's stubbornly holding at a level above where I really would like to see it. And so we continue to hear occasional comments about that, and so I said, well, let's add one more person and see if we can't make a dent in that. We also are looking at some additional capabilities for the phone systems that may have some budget implications, but we're working with DIR and the Capitol Complex phone system for some enhancements, so we'll report on that as they develop. Thank you.
I'm sure the public continues to appreciate the improvement. You know, I realize and appreciate the fact that it is stubborn in terms of there is still a hold time. However, it is far better than it was 2 years ago, and so we never want to let you let you know that we have not failed to recognize that. So thanks for the continued effort.
Good afternoon. Gwen Jackson, Director of Education and Licensing Services. If you'd please draw your attention to the TALCB report of active certifications and licenses. At the end of March, we had a total of 5,994 active appraisers. This total reflects an increase of 138 from March of last year. As you can see, the majority of that increase comes from an increase in appraiser trainees who are trying to get started in the appraiser business. Note that there are no longer any provisional licenses. The last one expired the end of January. Also, as a note, in addition to the 5,994 active appraisers, we have 133 appraisers who are inactive, and there are 640 who are licensed as temporary out-of-state appraisers. And future reports that I bring forward to you will include both of those categories. Any questions on this report? The next report provides the number of appraisal management company registrations and renewals. And as of March, we issued 15 AMC renewals, and we had a total of 190 registered AMCs. But then just hot off the press, for the month of April, we were able to get those figures as well. There were 33 renewals that were issued, and as of the end of April, we have a total of 192 registrations. Any questions on this report? The next report is the L1 report, and that report provides fiscal year comparisons for March for the number of applications received and licenses issued. There is an increase in total original applications received as appraisers apply and or upgrade prior to the January 1, 2015 effective date for the new AQB criteria. Any questions on this report? The next report is the examination activity. And there are examination results for the month of March as well as for the year-to-date results. The overall year-to-date pass rates through March are almost 43% for state licensed, 68% for certified residential, and almost 66% for certified general. The last report for ELS is a fiscal year comparison, and this one shows the overall pass rate for all appraiser types. It was at 59% this March, and we're at 68% for March of 2013. If there are no questions, that concludes my report.
Thank you.
Thank you.
Good afternoon. I'm Tom Watson, Director of Information and Technology Services. If you could turn to page I-1 in your books.
Sir.
We continue to see real strong results on the online renewal applications. So we are seeing utilization of those particular services, and they are very favorable in comparison to last year's results. So a continued strength in that area. Where we are seeing some weakness, though, is for the initial applications for online transactions. On this particular report, we are not showing any online utilization for the newly implemented initial applications for the individual licenses. So as a result of that, it is dragging down the annual comparison of year-to-year results for online activity. As last year we had the AMCs, which were highly utilizing that service. The individuals that thus far are not. And we are taking steps right now to take a look at what can we do from the website perspective to better publicize this particular service. So we're doing some research right now to see if we can improve those numbers.
We may want to piggyback that with education. A lot of times those people needing to make application will be recently going through classwork, so to the degree that we can put a bug in the ear of the educators that they can proceed online, that might be helpful.
Certainly. So with that, I'll be happy to answer any questions you may have.
Thank you.
One other thing that Tom failed to tell you about that we made a big deal about, or he made a big deal about at the commission meeting, was that we went through security testing with DIR, and as he likes to say, they failed to obtain any of their objectives of taking controls of our systems. So.
Fantastic. That's a really good job. Thank you for pointing that out to us. That's great.
Good afternoon. My name is Melissa Huerta. I'm Director of Staff and Support Services. And my report is the S1 report, and it's the budget status report as of March 2014. The items that I wanted to point out to you, you may have some questions afterwards of some of the other line items, but the main ones are the office rent, which you can see we've already paid. We made our first payment. We still owe, or we should owe another 50%, but because of the SWICAP allocated expenses, it's reduced what we owe in rent. And for the new board members, SWICAP is the statewide cost allocation plan, and certain state agencies provide services such as accounting, computing, payroll, and other statewide services such as the Comptroller's Office, DIR, the Facilities Commission. And so the SWICAP is the governor's office hires an outside firm who comes up with the costs, and then the governor's office allocates them to each of the different agencies. And then they in turn turn to the comptroller's office, who bills the agencies for their portion of the SWICAP allocation. So parts of the SWICAP, what's included, are costs that are associated with this building. And because we pay for the lease of this building, some of those costs are, because of the way the lease was written, we're able to deduct those allocable SWICAP cost from the lease payment. So as you can see on the budget, we show our office rent reduction, but we show a great increase on the SWICAP payment. But those offset, so it's actually a net. And actually, since we made our first payment and after we got the SWICAP allocation, we realized that we've overpaid. So we're waiting for a refund of $546, which they may offset, or they haven't determined how we're going to get that back. But so I wanted to make sure that y'all understood what the SWICAP was. Other items on the budget that are notable are down in the revenue. You can see that under the AMCs, we're very behind on where we should be, but actually it's because the AMCs aren't up for renewal, and the first ones are in May. So we're going to be, and right now, as of this report date, we've gotten 15 renewals of the AMCs. So those renewals will be kicking up, as Gwen talked about. We got some more in April, and we'll be getting them throughout the summer. So that should bring up the revenue under the AMC portion. Does anybody have any questions on any of the other line items?
I have a couple, please.
Yes, sir.
Back up on, I take it that registration and membership, those are just a one-time expenditure, so that's why there's just a very low balance on that, because we won't see that expense again for the rest of the
Yeah, there are some that are coming up this summer, but so we're going to be over what we budgeted, and so we've taken that into account. So when you see the budget for next year, we've increased that budget for that line item.
Okay. Same with maintenance and repairs?
On maintenance repairs, we paid the Versa maintenance at one lump sum towards the beginning of the year, so that's why that one's expended already.
I see, but you're running plenty of surpluses that even if that runs negative, you can cover negatives then.
Yes,
Looks
sir.
like you're in real good shape. I just had a question about those two.
Oh, yeah. No.
Thank you.
Sure. That's it. Thank you.
Oh,
Yes, ma'am.
Real quick, what is the, under utilities, field inspector phone service? What is that?
Those we had an item for a field inspector that we hadn't accounted for, and so it's for the web service, and so that was something that wasn't budgeted. So that's why that expense has been more than where it would have been, because it wasn't included in the budget.
And it says field inspector, but that's an appraiser investigator who
appraiser.
works from a home office
That's the question I was fixing to ask.
in
Oh,
Dallas.
okay.
Yeah, it's not an
I need
inspector.
to
Sorry.
change that.
I was wondering why the inspectors were on our budget.
I will change that. All righty. Okay, thank you very much.
Thank you.
Good afternoon, Madam Chair and board members. Mark Murnack, Enforcement Director with the board. So the first report there is the case status report for fiscal year 2014 as of the date there, April 23rd. Throughout the fiscal year, we had opened 181 cases of work, complaints of work, and as requested, we had put two different subtotals. So 91 of those were actually regulatory complaints, and 90 of those were comprised of experience audits, RFAs, and MCD inquiries, or moral character determination inquiries. And throughout the fiscal year 2014, we have closed 185 complaints, comprehensive of complaints from all prior fiscal years. And as of that date, we had 174 open complaints. No questions. Next slide, please. We duplicated that report for AMCs only, and to date we've had 9 AMC complaints open throughout fiscal year 2014, and we've closed 3 comprehensive of all prior years and had 7 open as of April 23rd, 2014.
Excuse me, Mark?
Yes, sir.
The complaints for the AMCs, where are they generating from, or are they coming from individuals? Are they coming from banks, or being?
I don't have that information readily available here, sir. What I do have is I have a report later on of all complaint types, comprehensive of appraiser complaints and AMC complaints, and who the complainants are of that. If you want the specific information in regard to who the complainants are for AMCs, I can provide that information either in a follow-up email or at a next board meeting. Okay.
Well, just to dovetail off of that, without compromising any investigations, what's in a general nature? What are the complaints against the AMCs?
General nature of complaints are varied, but most of them are in the realm of payment disputes that we do not get involved in. The latter ones would involve meeting the 5% audit of internally auditing their work, and a lot of the appraisal firms are using a short form that is not standard 3 compliant, and we've been trying to give notice to them to change, and so that's been some of the complaints. So that's just off the top of my head the nature of some of those complaints, but they're varied throughout.
Mark, Madam Chair, that's one of the questions that I had about the 5%. And I don't know if this is the right time to do it, and we can take it up later. But just in general, if you can, when an AMC is requesting to get their 5% audit, have we decided who can do the audit? Is it just any and all appraisers of equal status? So an AMC can call me and say, we'd like for you to check to see if this is USPAP compliant?
Mr. Garza, it's specified in the statute and then also in the rule in terms of who can do the audit for the AMCs. For instance, they need whoever performs that audit has to be of the same license category of the work being performed, or the report being reviewed. They need to have geographic competency, and so that's all detailed in that.
Yes.
So yes, if you were engaged by an AMC to do review work of work 5% of their work, you could do that for them.
So there'd be no consequence if you're not USPAP certified or whatever if you're doing that 5%.
You don't need to be USPAP certified to do those appraisals, but no, I mean, any appraiser, they can engage any appraiser as long as they comply with those detailed standards.
I just wanted clarification on that. I couldn't remember from 2 years ago when we were working with that. But okay.
Madam Chair,
Thank
if I can speak to that real quick. First of all, thank you for the report pulled out like that. I asked staff to please give us the report on AMC complaints in a very snapshot picture like this. But I did let them know that as we started to get more activity, if we get more activity, and that the board members might want to start seeing some detail of that. And I think we have very good templates from enforcement side to just go ahead and turn that information from AMC into that. So as you would like to see that, I'll be more than glad to go ahead and get them to start developing those reports. I do have a report that speaks specifically to your question about the what kind of complaints were what. So I'll be glad to give that to you. To the review and to a couple of other different items concerning AMC, we are continuing to look at that, and we're continuing to have discussions about not just the reviews, but also, like I said, the audit process that's coming down, customary and reasonable fees that are coming down, panel, how we're going to, implement the panel, add, subtract, everything like that. So there's a lot of stuff coming down from the AMC that we'll be reporting on in the future and that the AMC committee will be working on. Yes, sir.
Is that because it's hasn't been required yet? That's a coming federal regulation that will be implemented, is what you're saying?
The federal regulations are coming, and Doug can probably speak to this a little bit better because he knows the details of each regulation that's coming down. Is it May, Doug, that we are charged with getting?
There's an agenda item on that later, if you wouldn't mind, because I'll be reporting on it.
Okay, good.
Okay.
No further questions. Go on to the next slide, please. This is a report on total regulatory cases open as of April 23rd, and we'll make that title change going forward. But looking at this, currently we have 127 open regulatory complaints, and that is not inclusive of audits and moral character determinations, which when you subtract those out, it is 127 open regulatory complaints. So, which is a decrease of 8.6% from the prior report. Next slide, please. This report is a report of the cases open that are 1 year old or older. And we've seen significant decrease in this. Of course, we currently have 19 of those open, the majority of those being RFAs and coverts, as we know from the audit that was reported back in February. So. No questions here. Next slide, please. This is a report on our case resolutions for fiscal year 2014. We've had 111 total resolved complaints, 66.7 of those being percentage of those being dismissals. That is a slight decrease in that percentage, but it is historically in line with the performance measures that we used to report to the state of having around 30 to 35% dismissal rate. So nothing's really out of character there. Next slide is disciplinary actions 2014. Of the 37 disciplinary actions noted in the previous slide, noting that those 37 all result in agreed orders. We have had 2 recent cases that have gone to the State Office of Administrative Hearing, and they should be on the next board agenda. One was a default where the respondent didn't show up, and the other one was fully prosecuted through, and we are awaiting the proposal for a decision on that matter. No questions here. Go to the next slide, please. Mr. De La Garza, this is a complaint source for fiscal year 2014 of who those complainants are, and I can provide the detail in terms of those 9 AMC complaints in terms of who those complainants are, but Looking at this here, we have 91 total different complainants, and we have about 33% of that being the categories made up of financial institutions or people involved in the transactions, which are the AMCs, appraisers, banks and thrifts, Dodd-Frank referrals, federal and state regulators, and then mortgage lenders. 44% is the largest category, that being the 40 consumer complainants. And the third top category is staff initiated, with 17 or 18.7% of those. So.
And just for clarification,
yes, ma'am.
Mr. Marnak, the 6 for appraisers, that was an appraiser initiating against another appraiser?
That's correct. Yep. Whether it be a reviewer or any other appraiser. Next slide is enforcement case trends. Continuing on with previous 2 years, we are closing more cases than in a year than are opened in that same year, and so we are currently on pace of closing 22% more this year, and so happy to see that trend continuing despite reduction of one appraiser from last year moving on to take a new job. So we're still keeping trend there. So no questions there. Next slide, please. This is just looking at the different license types and the percentage of complaints received per that license type. And the next slide just gives a different view of that, of a point-in-time line chart. So not surprising that certified residential, being our largest license type, comprises the majority of complaints that we receive.
Mr. Marnak,
yes, ma'am.
Ask you the 4 provisional licensed. Can you tell me from this information how those were initiated?
I cannot. I can research that and provide that information, but I'm not certain. And I'm not even certain what they would be from 2009 to 2014. So I can go back and research that. I'm not sure when they occurred, but within that 5-year period, there were complaints against 4 provisional license types. 2011. So if the board, or if you desire, if the board desires, I can research that.
Clarifications being given up here. 3 of them are 3 years old.
Okay.
So just that one, and I don't need clarification for that.
Okay. No other questions? That concludes my reports.
Thank you very much.
Thank you.
Good afternoon, Madam Chair, board members. Tony Slagle, Government Affairs. The report you have before you is an updated version of the report that was provided last May, which is a demographic breakdown of appraisers since the peak of market peak of 2007. The numbers haven't changed very much since the last report, other than the age group of 35 and below slightly upticked. So there was a slight increase in appraisers 35 and under joining the ranks in Texas this year. If you don't have any questions on that, I can move to the next slide.
Thank you.
All right, and this is a comparison of Texas to national numbers. Unfortunately, the survey from the Appraiser Institute is from 2012. They have not updated those numbers, so it is a comparison to that. But looking at them, you can see that we are slightly more diverse than the numbers nationally. If you go to the next slide, you can see that Texas has slightly more male license holders than the national numbers, and we are slightly younger than the national numbers as well. So if anyone has any questions, I'm happy to answer them. Otherwise,
thank you, Tony.
Thank you.
Does that conclude the staff reports?
It does.
Will take us to agenda item number 13, discussion and possible action to adopt amendments 22 TAC 153.1 definitions.
Madam Chair, board members, Agenda item 13 is discussion and possible action to adopt amendments to Rule 153.1 definitions. The amendments in this proposal correct grammatical errors, clarify and remove outdated and redundant definitions to better reflect the current qualification criteria of the AQB. The amendments were proposed and published after the February board meeting. The board received one comment from the appraisal subcommittee during their audit, and the commenter noted that certain definitions were no longer used by the ASC and the AQB, and these definitions were not referenced elsewhere in the board's rules. So the amendment has been revised to delete those outdated and unused definitions. The board agrees with the commenter, and with those revisions, none of which are substantive, staff recommends adoption of the rule as presented. The executive committee has also reviewed this proposed amendment and recommends adoption of the amendment as revised.
Thank you. Go ahead.
I have a question, Madam Chair. Just if you could tell me a sample of definitions that are no longer used that we were using here.
Sure. Those appear at pages 149 of your materials through 152 of your materials, and the highlighted in yellow portions of those pages show the revisions that have been made. So for instance, we have deleted the definition of authorized supervisor. We have replaced appraisal process with appraisal practice. We have deleted evaluation. We have changed the term complaining witness to complainant. We have deleted provisional license. As you heard earlier in the staff reports, we no longer have any provisional licenses. We've also deleted definitions for restricted use appraisal report, review, rule, summary appraisal report.
As those are no longer terms utilized in the industry by changes that have occurred over the course of the last few years, they've either been substituted with other words or they're substituted with other practices.
And they are not referenced anywhere else in the board's rules.
Additional questions of staff? Floor is open for a motion.
So moved by staff.
I'm sorry, I didn't understand the motion. So,
okay, I will read it out. Moved that staff is authorized on behalf of this board to submit for adoption amendments to 22 TAC 153.1 definitions with changes presented by staff to text as previously published to the Texas Register, as well as any technical or non-substantive changes required for adoption.
Thank you. I appreciate the clarification. Motion is by Ms. Fontana. Second was by Mr. Beard. Is that correct? Is there any discussion? All in favor? Aye. Anyone opposed? Takes us to agenda item number 14, which is a discussion and possible action to adopt amendments to a number of rules, and I'll let staff summarize those for you.
Madam Chair and board members, this agenda item deals with proposed amendments to Chapter 157, rules relating to practice and procedure. This particular chapter was previously opened for review pursuant to the board's quadrennial rule review process. These amendments were proposed at the February board meeting and published in the Texas Register on March 14th. No comments were received on the amendments as proposed, and staff recommends the board adopt the rules as published.
Questions of staff? Hearing none, the floor is open for a motion.
I move the staff is authorized on behalf of this board to submit for adoption amendments to 22 TAC 157.3, Scope of Rules, 22 TAC 157.4, Computation of Time, 22 TAC 157.5. Oh my gosh. I didn't realize it was that long.
How about all of Chapter 157?
How about we just say...
I did laugh. I said, when you turn the page, you're going to be surprised.
Yeah. Can we just do it as proposed? Authorize on behalf of the board to submit the amendments as proposed by staff?
Is that acceptable?
Yes,
General
that would be
Counsel?
acceptable.
We do have a motion that's acceptable. Is there a second? So we have a motion from Mr. Beard and a second from Mr. Padden. Any discussion? All those in favor?
Aye.
Anyone opposed? Very good. That takes us to agenda item number 15, discussion and possible action to propose amendments to 22 TAC, Chapter 153, rules relating to provisions of the Texas Appraiser Licensing and Certification Act.
Madam Chair and board members, this agenda item deals with the proposal of amendments to Chapter 153 pursuant to the board's quadrennial rule review process. The amendments are being proposed to simplify and clarify where needed and to conform our rules with the criteria established by the Appraiser Qualifications Board. For instance, the proposed amendments capitalize the term board and replace the term licensee with license holder throughout the chapter. The proposed amendments also remove redundant or unused provisions and restructure certain rules to improve readability. Other specific amendments have been detailed in the recommendation included with your materials. Staff recommends to propose the amendments as presented. In addition, these amendments have been reviewed by the Executive Committee. The proposal for amendments has been reviewed by the Executive Committee, and the Executive Committee recommends the proposal of these amendments.
Madam Chair,
Yes, sir.
I move that staff is authorized on behalf of this board to submit amendments to 22 TAC and the various subsections of Chapter 153 as presented in our workbook.
Thank you. We have a motion from Mr. McAnally. Is there a second?
I'll second.
We have a second that will give Mr. Black credit for that second, since Mr. Beard has a few on the record. So the floor is open for discussion. I think there may be a question.
Madam Chair?
Yes, sir.
My question would be, the fees that are presented here, have they changed? Are there any increases, or are they the same?
No, there are no proposed changes to the fees. The only proposed change is to recognize at page 169 of your materials, item 22 has been added to recognize that an examination fee, as provided by the board's agreement with its vendor, will be charged for the examination.
We already charged for the fee already.
That's correct, and this provision is simply being added for clarity.
Okay. That was my question. Thank you.
Madam Chair, just for clarification, if I may, Kristen, there was one that was before the board last board meeting where there was a large paragraph that we were going to look at executive committee level, and we did. Can you point me to that particular?
Believe that is Rule 153.9 with respect to applications, and that appears at pages 170 and 171 of the board materials. And there was a timeline that related to the application and the date that an application would be denied, and then an applicant could reapply to the board 1 year after the date the board denies that application. So that any time that, if the applicant chose to pursue an appeal of the board's denial of his initial application, that time would not be counted against the applicant.
Thank you.
We do have an active motion and second. We are still in discussion. Are there other questions?
I have a question, if I could.
Yes, sir.
Madam Chair,
Mr.
does
Barba?
anything here address the mentorship program? Who's qualified to be a mentor? I know you have a lot for, of course, how to take examinations and renewals and discipline, but what about the mentorship program?
The rules in Chapter 153 do not address the mentor qualifications.
Okay, that's all I need to know. Thank you.
Thank you. Other questions? Hearing none, we have a motion and a second. All those in favor?
Aye.
Aye.
Anyone opposed? Thank you. Motion passes unanimously. Carries us to agenda item number 16, discussion and possible action to repeal TAC 153.16, a provisional license.
This agenda item is presented as part of the board's quadrennial rule review process. The proposed repeal is recommended because we do not have any provisional license. As you heard earlier in the staff reports, the last provisional license issued by the board expired in January, and we are no longer issuing provisional licenses. So staff recommends that this repeal be proposed as presented. This proposal was also vetted by the executive committee and is recommended by the executive committee.
So moved, Madam Chair, to accept this presented.
Motion by Mr. De La Garza. Is there a second?
Second.
A second by Mr. Barba. Is there discussion? All those in favor?
Aye.
Anyone opposed? Motion regarding provisional license passes unanimously. It takes us to agenda item number 17, discussion and possible action to close the review of 22 TAC Chapter 155, rules relating to the standards of practice, 22 TAC Chapter 157, rules relating to practice and procedure.
Madam Chair, with the amendments just approved by the board for the rules in Chapter 157, the board has completed its review of Chapters 155 and 157, and staff recommends the closing of the review of those rules.
Thank you. Are there any questions of staff?
Madam Chair,
Yes, sir.
move that staff is authorized on behalf of this board to close the rule review of 22 TAC Chapter 155, rules relating to standards of practice, and Chapter 157, rules related to practice and procedure.
Thank you. We have a motion by Mr. McAnally. Is there a second?
I'll second it.
We have a second by Mr. Beard. Is there any discussion?
Yes.
Mr. De La Garza?
Chapters 155, I see chapter 157, but I don't see chapter 155.
And that is correct because we did not have any corrections or amendments to Chapter 155 as part of our rule review process.
Was it presented at the last board meeting?
No, there were no changes that were required. The staff reviewed the rules in Chapter 155, and those rules comport with our current practice and the AQB criteria, so staff did not recommend presenting or amending any of the rules in Chapter 155.
So just explaining the process a little bit, by us closing the review, it means that they're not going to be posted for public comment, or do we just move on, or?
It simply means that we are closing the quadrennial rule review process. It does not foreclose the board in the future from looking at one of those rules in Chapter 155 and proposing amendments at a later date. It's simply a closure of the quadrennial rule review process. So, as you may recall, we published notice in the Texas Register that we were opening the rules for review and that we would publish any amendments that were being proposed to those rules as part of that review process. And so this just represents the closing of that process.
And we did have some comments on either of the opening, when they were in the Texas Register. Do we have any comments?
On Chapter 157, we did receive no comments on the proposed amendments to that chapter.
Okay, thank you.
Sure.
Is there additional discussion, questions? No? All those in favor?
Aye.
Anyone opposed? Motion passes unanimously. We will move to agenda item number 18, discussion and possible action to propose the review of 22 TAC Chapter 159.
Madam Chair and board members, this item proposes the opening of Chapter 159 as part of the board's continuing quadrennial rule review process in accordance with the plan that has been previously submitted and published in the Texas Register. Staff is recommending that we publish notice that Chapter 159 will be open for the receipt of comment, and any proposed amendments will be brought before the board at its meeting in August for the board's consideration, and then those amendments would be published in the Texas Register with an additional opportunity for comment.
I have a question, Madam Chair.
Yes, sir, Mr. Barber, proceed.
Do you anticipate a lot of commentary on this, on the rule review for the Texas, for management companies? As I understand it, there's a lot of activity surrounding these entities. Do you expect there'll be a lot of substantive comments that would be pretty perfunctory like the last few rule reviews?
I believe that it would be premature to speculate on what comments we might get because we haven't actually gone through the process to review the rules and recommend any amendments at this time. My guess is that these amendments would be considered by the AMC committee, and the AMC committee would work very closely with staff to develop any proposed amendments. And then, depending on what those amendments are, we might receive significant comments, but we may not.
Madam Chair, if I may, Mr. Barber, I do anticipate quite a bit of activity, quite a bit of discussion on these rules.
So my follow-up,
from the public and
so my follow-up question is staff prepared to take a lot of extra time to do a review on rule changes to this particular chapter, unlike the other ones, which seems pretty legal, pretty straightforward, deleting definitions, updating language, things like that. This seems like it's going to be quite of a substantive change in the way that we regulate AMC, so I don't know if staff was prepared for that kind of undertaking or not.
Mr. Barber, let me add that I've just come off as chairing the AMC subcommittee, and so I'm not sure that the changes will be it will be more about an education process and potentially clarity in the rule is what I would expect. And so I do expect, and as has already been commented by the current AMC chair, that they've got some committee work ahead of them. And I think the question really is, are we ready to get ahead of the curve? Because it's going to take a little time to do that. And it's more complex in just simply going line by line and having both the public and the committee talk about what the expectations were, is there clarity in the rule, those kinds of things. So I suspect that we're all anticipating the possibility of it taking some time at least to get through the review. How much change will need to be made, I think, is probably still up in the air.
Madam Chair, I have a question. Then as we roll out the new federal required rules, do you go back and readdress this rule later on, or you have to reopen it, or?
Actually, the timing is fortuitous in that we will have it open for review at the same time that we are commenting on, we see what is in the proposed federal review.
Okay.
And then there will be, I guess the possibility exists that after the end of the federal comment period, that amendments are proposed at our August meeting and published, and perhaps sometime during that comment period for our rules, the federal rules will be published after their comment period. And we may have to repropose in November, if necessary, to accommodate any changes that we didn't anticipate that are in the final federal rules. And then, of course, we may also have to go to the legislature and ask for some changes to Chapter 1104, the statutes, to be consistent with the interpretations of the federal rules of the interpretations contained in the federal rules of the Dodd-Frank Act.
Yes. Yep. Okay. That's what I was wondering, if it's going to just do double work, or if you're going to be able to sync them up pretty much. In a sense, yeah.
Other questions? I believe the floor is open for a motion.
Madam Chair,
Yes, sir.
I move that we accept agenda item 18 as stated, if I can do it that way.
Yes, you may. Thank you, Mr. Black. The motion for approval by Mr. Black. Is there a second? We have a second from Ms. Fontana. Discussion? All those in favor?
Aye.
Anyone opposed? I believe that takes us to agenda item number 19 in pending business. 19 is discussion and possible action on recommendations coming from the Enforcement Committee. There are items A through E as reported there on your agenda.
Madam Chair, through our last Enforcement Committee meeting, we have discussion and possible action on recommendations from the committee regarding changing to the language in the board orders from certified funds to cashier's check or money order. And this is to clarify how respondents may submit payment for administrative penalties.
And the committee recommends making the change.
Yes, ma'am.
Are there any questions?
Yes. I'm sorry, I'm seeing that there's, on the same 19, we have items C and D.
I believe Ms. Fontana has only opened 19A at the moment, but certainly if you would like to talk about them all collectively, we can consider that.
Is it just 19A then?
Yes,
At the
sir.
moment, that's the only thing.
Okay, I'm sorry.
No problem. I did create the confusion by commenting that they were A through E. Would you like to take them up individually? Yes. Maybe, okay. So agenda item number 19A regarding the change of language from cashier's check, from certified funds to cash, adding the clarification of cashier's check and money order is open for discussion. Or a motion.
So moved.
We have a motion
As presented.
for approval by Mr. De La Garza. Is there a second?
Second.
We have a second by Mr. Barba. Is there any discussion? Not all in favor?
Aye.
Aye.
Anyone opposed? Takes us to agenda item number 19B.
19B is discussion and possible action on recommendations from the committee regarding including the category of properties being appraised in all board orders, meaning to list in those orders that if it's general, residential, licensed, trainee. And so we recommend that those different categories are listed on each order.
Just for the sake of conversation, just explain it a little bit more, what it is or where it's coming from.
Madam Chair,
Oh, I'm sorry. Yes, Ms. Warman?
if I could clarify, most of these issues were raised at a previous board meeting and were referred to the Enforcement Committee for their review and recommendation. And this particular item, 19B, was a request of a board member that the category of the property be noted in the board order.
Oh, I'm
And the
so
committee
sorry.
recommends that the board orders include that item.
Okay, thank you for the clarity. Does that help you, Mr. De La Garza?
Yes, I move that we approve that. As
Thank you.
presented.
We have a motion by Mr. De La Garza on the floor. Is there a second? Second. I have a second by Mr. McAnally. Was that you? Okay. Motion and a second. Discussion? Hearing none. All in favor?
Aye.
Anybody opposed? Motion passes unanimously. It takes us to agenda item number 19C, discussion and possible action on recommendations from the Enforcement Committee regarding criteria that PIC members be certified as USPAP instructors.
In our discussions at committee level, and what we're recommending is for the PIC members to continue to be USPAP certified instructors. And we had quite a bit of conversation about this, and we felt it was important for those to remain to ABQ.
For the sake of the new board members and the public, can we talk about what is PIC?
Absolutely. Go right ahead.
It's a peer investigative committee. It is a process in which the enforcement staff, a board member will sit as the board representative of a region, I guess, and we'll have several people that are ABQ qualified and instructors that have qualified to be a PIC member, and they will at times review some of the complaints and the reviews of those complaints, and then report back to staff.
Madam Chair?
Yes, sir.
If I may, just a little bit of historical history on that is that its peer investigative committee was used when this agency was very far behind on the review of the cases. And I think as we deliberated this issue, since we are now caught up, we don't use these individuals as much as we used to, but we felt as a committee that it was still important, even as seldom as we may use them now, that they still have the credentials of being a USPAP certified instructor.
I would encourage, and certainly that's a board decision long-term, but I think you need to keep that active by meaning that even if we are caught up, I think those people that have volunteered to serve out in the peer active appraisal business need to be fed a peer review at least once a year, that we never know when we may be inundated again, and it's simply, I think, a good practice to keep us in touch with those folks that are out practicing. So essentially what happens is an enforcement complaint comes in, staff will decide which ones seem appropriate to send out to real people in the real world doing, real estate appraisal review, and they have to meet certain criteria to be able to have the opportunity to even serve in that capacity. Once that person completes a review, it comes back to a board member who's also serving and the staff for a review of the review, if you will, and then a recommendation is made to our enforcement staff on how to proceed. Hopefully that's clarity and not confusion.
Is the recommendation made straight to staff or to the committee?
I believe the recommendation from the PIC member is made to, I guess it goes to staff, right? But it's also reported to the board.
Correct.
I think I'm the one that raised this issue, the possibly considering others. I think it's a moot question because of what Mark said. I don't think we really need them, but geographic competency is one of those criterias. And if you're in an area that you don't have a USPAP certified instructor there to oversee either that PIC member or that individual, they probably wouldn't send it to them anyway, but you have to have geographic competency. And in some cases, like in, I don't know, maybe the Panhandle or El Paso or down in the valley, you may not have someone with geographic competency that's also a USPAP instructor and or PIC member. And that's why I was suggesting that's a possibility, but it's a non-issue. I think we're good.
I think it's one of those great conversations for us to have and to continue to explore if the need arises. So we appreciate the fact that you opened up the question.
And Madam Chair?
Yes, ma'am.
Just to clarify, the issue was also raised to consider that criteria for mentors as well, and that issue remains pending before the Enforcement Committee, and they're still considering whether to retain that criteria for mentors.
Thank you.
Madam Chair, I agree with your comment as to continue to send work out to the existing PIC members to keep them tuned and make sure that the process continues to flow properly. I think I would suggest that you suggest to the staff that periodically they send out a review to the members. And with that said, I'd like to make a motion to go ahead and accept the proposal as presented.
Thank you. We have a motion from Mr. De La Garza. Is there a second?
I'll second it.
We have a second from Mr. Beard. Is there discussion? Hearing none, all in favor?
Aye.
Any opposition? Agenda item number 19C passes unanimously. Carries us to agenda item number 19D. I'll let you go ahead.
This is discussion and possible action on recommendations from the committee regarding taking no additional action to inform SOA of the federally mandated deadline for processing complaints. This was raised by a board member, and if you don't mind, Kristen, talking to the details of that discussion.
Certainly. The Federal Oversight Agency requires us to process our complaints within 1 year from the date they are filed. And a board member at a previous meeting suggested, well, there might become a need if a case was referred to SOA for a hearing, that we would need to inform SOA of that federally mandated deadline. And what was discussed at the committee was that SOA already has a process in place for us, for our enforcement staff, to file a motion to expedite the proceedings, to make them aware of that deadline and a need to process our complaints within that federally mandated deadline. And our enforcement staff does routinely make use of those motions when needed, and we have never run into a problem where SOA has denied a motion in that regard. And so because of that, the committee recommends taking no additional action on this particular item.
Kristen, I have a question. So if we don't document the request, this is the way I hear it, at SOA, and simply rely on the process or procedure that we've been using, or do we have any risk about it impacting our grade, if you will, from ASC?
Certainly, to the extent that once we turn it over to SOA, the ALJ, it's not unusual for parties, for a variety of reasons, to seek continuances, and we simply have no control at that point whether or not we've sought expedited handling. If the judge decides to grant a continuance, yes, it could have an impact. We have made our ASC liaisons of the auditors who come to visit us, assigned to Texas, well aware of those considerations, and they look at that. In fact, we received specially documented circumstances for a couple of continuances that were for the health of either the respondent or the health of the respondent's attorney. And it did not negatively impact us this last time. So it's kind of on a case-by-case basis.
Thank you for the clarity. Additional questions, comments? It's the pleasure of the board. Yes, sir.
I move that we take no additional action on this agenda item.
Okay. A motion to take no additional action by Mr. McAnally. Is there a second?
I'll second it.
I have a second by Mr. Beard. Discussion?
Yes. If there's no action to be taken, so doesn't it? It's more of an informational piece than a motion.
Yeah, it was given to committee, and so the way I understand the action is it just simply closes the issue.
Okay.
Additional discussion or questions? Hearing none. All in favor?
Aye.
Anyone opposed? Motion passes unanimously. This is to agenda item number 19E, the infamous flowchart.
Infamous flowchart, I'm telling you. Discussion and possible action on recommendations from the Enforcement Committee regarding adopting flowcharts of complaint process for posting on the website. Just to give you a quick brief on that, as you will see in your materials, you have a like a big picture flow chart. There's a general idea of how the complaint process happens. And then you will also see in your material a more detailed one. The way that we discussed it at committee was we would like for the larger flow chart to be on the website with a link to the more detailed one underneath it. And then I would like to also remind staff and Kristen that we also decided to put a link to the full document on the process underneath it also. So as you go down, you will just get more details of the process of the complaint process. I also would like to take a moment before any other discussions and thank Ms. McClendon for bringing this to committee level and working so hard on this with Tony. Thank you very much. Staff for all the great interaction and the dialogue there to help not only committee understand what was going on, but also to meet our charge there, I believe, was transparency, and to allow not just the public to be informed, but for us to say this is what we're doing. I'd like to thank also Bobby Crisp from ATA and Jim Waller. They had quite a bit of great input on this flow chart. And as I said in committee, I would please like to continue to ask those associations to bring us feedback out and also help hold us accountable. Hold us accountable to this flow chart. Now that we've got it out there, as it was stated in committee by staff, let us know. Let us know if it's has any issues there. Besides that, any discussion on the flow chart as y'all view it?
Ms. Fontana, if I, all right, so currently then there is no flow chart like this on the website. This would be new information.
Correct.
Well, I would like to say, looks like y'all done a lot of work here. Looks very nice.
Thank you. It was a long process.
It was a couple of year process, and
18 months at least.
I'd like to add to the people that we appreciate their input. The legal counsel, both Ms. Warman and Carrie, spent a lot of dedicated hours trying to vet out questions and conversation and interpretation, and it was an intense process. And so there's a lot to absorb here, and we recognize that. Those of us that have been working on it still stare at it a little cross-eyed every once in a while. And we would have never finished without, and Ms. Fontana's already given him some credit, but Mr. Slagle, if you hadn't figured out how to get it all on one page, we'd still be here. So thank you very much for that. I'd only make one other comment that's been made to me. There was a significant amount of discussion regarding the labeling of this document, and you might remember that over the course of the last couple of years, at least especially at the enforcement level and all the way through the board level, an attempt to change the language associated with something that arrives on our doorstep as a possible complaint. So we talked about changing the title to intake and things like that. You'll notice there's still some labels there, and I've had some public comment about that, and I would just simply remind us that the statute requires that we parallel the language, and so that's why you still see the label being complaint process. You'll notice our desires of the word intake incorporated into this flow chart.
Madam Chair, once we put this chart out on the website and everything, and a public member or an appraiser would like to make a comment on this, what would be the process that they could? Would you all consider this, or would you? They would just say, I don't like it, or I like it, or.
Well, that's a good point. Maybe in the unveiling of the flow chart, maybe there should be some consideration given to some informational language above it or below it, allowing for contact information. I would think maybe to an enforcement committee member might be a good place to take it up, but certainly the floor is open for conversation.
You know, just somebody from the public may want to comment on and make a recommendation. I mean, I don't know.
Board members, we anticipate including this item, assuming it's adopted and approved by the full board, in our next newsletter as well, and we'll solicit comments from all of the appraisers with respect to that.
That answers my question.
And then we'll make sure that those get back to the enforcement committee, which is, I think, the appropriate place where this was born.
And I also failed to point out that ATA and FACT did send this out for public comment and came back with several different comments that were brought forth from the public. So it has been vetted through at least those two associations. And also, I'd like to also remind y'all, this is a living, breathing document. So as we see things that might need to be further addressed or further clarified, we definitely can take those under consideration.
Thank you.
And because the document is difficult to see in our media setting, you might notice, or I'll point out to the board members, on the bottom left-hand corner, there is no approval date, and it does say for informational purposes only. So to let someone that's looking at the document know we haven't completed it, although we're getting close, we hope.
Yes.
I have a question, and it's probably not the appropriate time to ask the question, Madam Chair, but I know that we have a statute that requires when we get a complaint, it must come here and we must acknowledge the appraiser has had a complaint filed against them pursuant to statute. And then I was always also told that you can't ignore that under the current law. They had to go into their record and be processed. Is that going to require changing the statute in the next legislative session if we want to have it so that it doesn't become an official complaint? Or is that a possibility that it can be not be a record, a part of their record, their permanent record? Isn't it so that even though it goes through the intake process, it's still filed, that they've had a complaint filed against them?
I'm sorry, we'll have to have some staff help. I see both of them grabbing mics. We'll start with the commissioner.
If a complaint passes the contingent dismissal stage and gets to an agreed order or any of the more formal processes, that has to be reported on the national registry, that discipline. But the non-disciplinary, all of the contingent dismissal up to that stage on the process so far is not a part of their record.
Okay.
So on your flow chart, if you look to the far right-hand side, that dismissal with warning or contingent dismissal?
I understood that there was a process through the complaining about a lawyer, for instance, that it doesn't hit the radar screen at all if it's dismissed or it's found to be frivolous. And I guess we're in the same category then. We don't, if it gets out of it hits the intake process form and it's found to not have jurisdiction or whatever, then it doesn't go on that appraiser's record.
Externally. Internally, of course, we have those records, and they are subject to Public Information Act requests, those kinds of things, if someone wants to dig and find it. But as far as the publication of discipline on the National Registry, there's certain requirements, and then on our website, there are certain requirements. But outside of, as far as the publication goes, but up through contingent dismissal, no one would know unless they came to ask.
Okay.
We don't publish it.
Madam Chair, and just to clarify on the flow chart, I think that is detailed by the coloring of the chart itself. The upper boxes, which are colored in the blue, represent that informal process and the review of the complaint intake form. And then when you get to the green, that would be the point at which a formal complaint is lodged and processed and investigated. And then the gray boxes represent the appeals process.
Very good.
Great work, Ms. Fontana and committee. That has been a long time in being developed, and we do appreciate it. Floor is open for a motion. I'll move approval of the flow chart of the complaint processing for posting on the website for public comment.
Second.
A motion by the chair and a second by Mr. De La Garza. Is there any additional discussion? If not, all in favor?
Aye.
Anybody opposed? Now, I realize we're at the slump level of this agenda, so gentlemen, if we need to take a seventh inning break, just let me know. If you need to stand up for a second. Do you want to do that? Yes. We have gotten a request for a brief break, so if we can do about, I guess, a little less than 10 minutes if possible. We are now at 1:30, and we'll attempt to return, well, a little past 1:30, 1:32, and we'll attempt to return in about 10 minutes. It's been reported to the chair that we have a quorum present at the dais, and so we will be returning to action items. It's 10 minutes. Wait a minute. It's 45 minutes after 1 o'clock, and apparently I can't read the clock from here. And we now have a full quorum of board returning. The next item on our agenda is item number 20A, discussion and possible action regarding recommendations from the Executive Committee. The first one is the annual half-day board training workshop. This has come from a long-developing recommendation to create a half-day training, and the floor is open for questions or a motion.
Are we just addressing 20A?
We are.
I move that we accept it, the annual half-day board training workshop.
There's a motion for acceptance. Is there a second?
Second.
A motion from Mr. Black, a second from Ms. Fontana. Any discussion? Not all in favor?
Aye.
Aye.
Anybody opposed? Motion passes unanimously.
Madam Chair, just for the sake of discussion, is this going to be the day before the November meeting, or are we looking at the morning of the meeting and then have the agenda in the afternoon? Or
You may recall there was a great deal of conversation at the last board meeting about this board making decisions about future boards' desires. So it's written in a way that gives you plenty of flexibility.
And I'm just, as I'm preparing for this coming November, are we looking at possibly having it?
My guess would be, it certainly will be at the pleasure of the board, but my guess is it would be probably the day before our board meeting. We will circulate that request for comment and final decision sometime soon. I recognize everyone needs to plan. Do you have a recommendation, Mr. De La Garza?
Well, the two options I'm looking at is obviously the day before, but what if we held it in the morning of the board meeting, do the half-day session, and then have the agenda in the afternoon?
Because we've been so efficient at getting through board meetings in less than 4 hours, I think that's a great idea.
We have a new slate. We have a
history of that.
We have a new slate, and I think we're moving quite along.
That's certainly a possibility to consider, and it's
just comments.
Why don't we look at what we think it's all, I believe a fair portion of the training is developed, and why don't we let the Executive Committee ask for circulation, both information from staff, and we'll report to you all and see if we can't give you plenty of advance notice.
Thank you.
Agenda item number 20B, discussion and possible action regarding the recommendations from the Executive Committee about the leadership transition. This also is something that's been in conversation for a while. Essentially, it just memorializes the concept of getting a slate of officers out to this board prior to the actual February board meeting. Questions?
Yes. As I'm reading the recommendation, I think it's a fantastic idea that we have at least a slate of officers the meeting before, and it would be in the November meeting for the officers for the November. It would inform the board members and the public what we're doing. I think floor nominations are excellent way of doing it, and I would go with that without hesitation. I do have a question or a concern about the Executive Committee making a recommendation as to who should be on that.
Okay. That's certainly open for conversation. I believe that's been the historic practice, is the...
No.
Okay, then let's talk about that.
The no-
Certainly was the most recent, I believe. Did, Mr. Beard, did your executive committee submit a slate of officers to this last board?
Yeah, what we had talked about was making it be, like you had indicated, get it out in November to make this recommendation. I think what Luis is saying, he's thinking it's like it's rigged or something, that we're rigging it for the next year, who's going to be in various capacity in the following year, and he's got a concern about that. The attempt was just to get it out there so that somebody else wanted to have the opportunity to serve in one of those seats, those capacities. We'd all know about it, so that it come February, it wasn't such a confusing meeting.
Agreed.
And that it would all be taken care of.
And I'm sure that the rest of the board's probably open to any other suggestions, Mr. De La Garza. I think the issue is simply that who's going to take the lead asking if people are interested in serving at a leadership capacity, because my experience in other locations is without at least some conversation there, then everybody stares at one another, because in an open meeting with an open floor nomination, it's seldom efficient in terms of time, because simply, so what happens is a motion for nominations is sitting there, and if Mr. Barba wanted to serve in executive capacity, he may or may not feel comfortable saying, hey, I'm willing to, in that open setting. So I'm fine with, if you would, are you saying you would prefer it to simply say floor nominations?
That's it.
Okay.
That's it. I totally agree with the concept. I totally agree with having it in the nominations in November. I think it's a fantastic idea. I just have a little problem with the executive committee starts making recommendations as to who should be in that.
Okay. When the executive committee's here and we had made a recommendation at this current language, does it make either? I suspect it doesn't bother me at all if you eliminate it down to floor nominations. I think the history of why we had the executive committee making the recommendations I've already expressed. So I'd just like to ask Mr. McAnally and Ms. Fontana, does it give you heartburn to remove that?
No, not at all, as long as we're doing the floor nominations prior.
Exactly.
Yeah, that's fine.
And for clarity, I suppose even at the February meeting, I don't believe there's any intention to close the door. So instead of there being any recommended slate of officers, is what you're asking for, that they simply be verbalized at floor nominations level. And then, of course, at February, at the time of actual election, floor nominations are also allowed even at that point.
There you go.
Okay, is that?
I'm sorry. It seems like you'd need to have some kind of wording in here to make sure it's done before the February meeting, or we're just back to where we were.
It says at the last board meeting of the calendar year, so
Okay.
it's there, unless you don't think that's clear enough. So it says, at the last board meeting of the calendar year, the board will include the following items on the agenda.
And I like that language, because if for whatever reason we have to move the November meeting to December or prior, it covers all the last meeting of the year. So I concur with that language. I think it's well thought out.
So this memorandum will just serve as a permanent agenda item placement?
I believe the request, or the question was, by adopting this board memorandum, would it create a permanent calendar placement? Yes, and unless changed by some future board.
Agenda placement of this
Agenda
item,
placement of
yeah.
this item.
Okay.
So how is this different from the current process then?
There really wasn't one, Mr. Black. It was fairly informal, and so what would happen up until this conversation, which has been ongoing for about, I don't know, probably 18 months, is we would arrive at a February meeting, and essentially Mr. De La Garza's recommendation of floor nominations would happen, and then you would actually vote right there. So it was incredibly uncomfortable. For instance, maybe you've never had this experience, but I've had great friends who have sat at the far end of a dais from me, and without ever asking me, say, I move Ms. Wycliffe chair the board next year. And so at that particular meeting, without any break or opportunity to communicate, my name would be out there. Of course, you can decline the nomination, but it was very awkward in terms of processing. So I think all we're trying to do is put some structure in place, nothing more.
Thank you.
And so that process will take place in November, or the last board meeting of the year?
Yes, sir.
The recommendations.
Yep.
Well, there won't be any recommendations based on what I hear you, based on what I hear you saying you prefer. And if the board adopts your preference.
And we could have 2 members for the same position.
Oh, yeah, or 3 or 4, absolutely.
Yeah, 3 or 4 positions, correct. Okay, just...
Not to push in more into this, but I guess the way that we've historically done it, the chair is the one that does the committee placements there, right? Assignments, thank you.
Yeah, that is, I think, already established, and that would not happen until after the election.
All right, thank you.
Well, another thing too, in the way it's been done in the past, when this gets posted as on the agenda as an open meeting, and you have board members without any kind of structure calling each other, consulting with each other, then I can see our attorneys over here going, you know what, y'all are starting to get real close to a walking forum here. And so I think that by having some kind of committee, if it's executive committee or whatever committee it is, to at least hear board members' interest if they want to participate or hold an office, and then be able to formalize that. Is that where you're going, Madam Chairman, with this? Is that, or am I missing something?
No, I think that's where we originally intended, was there to be, I certainly don't think any of us are looking to create a forum where now the candidates have to come and speak in some public setting. I don't think that's been an issue in this organization. So if Mr. De La Garza feels like there's more transparency simply from floor nominations, I don't guess I have a problem with that. I do think, we'll see how the practice turns out. I suspect it'll still be a little bit awkward unless we have some people as a central point of conversation, which is what the executive committee recommendation would have allowed the opportunity to do.
And just to reiterate, I believe that the last board meeting that we have, we know who's aspiring for his position. I think that's the key to bringing the structure. And again, in February, if somebody else wants to, but at least we have some ideas to who is interested in what position.
I think that's what we're trying to achieve, and I think that's important.
Thank you.
Is any additional questions, discussion? Floor is open for a motion.
So move, Madam Chair, to accept the recommendation for the board for the leadership transition, except for the executive committee recommendation, and for nominations, floor nominations for officers, the executive committee.
We have a motion. Is there a second?
I'll second.
We have a motion from Mr. De La Garza and a second from Mr. Black and I'm going to attempt to restate the motion to accept the board memorandum as presented with the exception of striking item number 1, executive committee recommended slate of officers, and leaving only floor nominations, and I might recommend we add the language to create a slate of officers. Is that an accurate depiction of your motion, Mr. De La Garza? All those in favor?
Aye. Aye.
Anyone opposed? Motion passes unanimously. It takes us to agenda item number 20D, discussion and possible actions on the recommendations of the Executive Committee regarding the ASB program for drop shipping USPAP. Did I skip C? Sorry. Thank you for the correction. Let me back us up to agenda item 20C. There's one way to get finished quicker, right? Oh, no, and especially this one in particular. No, it wasn't on purpose. It stuck to my B. Statutory per diem and travel reimbursement, and for those members of the public that haven't had the opportunity to hear the debates on these issues, it's also been a long-standing topic of conversation amongst this board in terms of trying to get clarity on per diem. I hope you all have had an opportunity to read the detailed report that we've provided to you. There is a recommendation by your executive committee after much vetting at our level on how to clarify those issues that had been in question, and the floor is open for questions or comments.
Madam Chair, if you wouldn't mind, just a quick comment. As we were discussing this particular item, there was some verbiage used, and this is just for discussion. Whenever we present this form to the new board members or present board members for the first time, I would like to know to what extent are we going to inform them, you know, what exactly this is, and give them the policy backing the whole form.
I believe that's in the training manual, okay. So I believe it's intended to be addressed in their half-day orientation.
Okay. And then just the wording. It's per diem and travel expense reimbursement election form. If I remember right from the discussions, the discussion was actually that the only election that would come would be a secondary one. It's intended to be an opt-out only. So the board member would be automatically opt-in to this, and the election would only be to opt-out.
Well, but
then,
would you agree that the form in its current format is what is more clear for someone to be able to follow? I mean, are you concerned that the presentation to the board member is not clear?
There again, just and specifically my concerns with this was that when the board member was giving this first up, that they understood that they automatically are they have the right to get this per diem and the stipend.
Entitled to.
Entitled to it.
Okay.
This form is only to opt out of that entitlement.
Okay, and I just don't want there to be confusion. I thought the reason we adopted it the way we had is so that staff would, so that if there was ever a question, the two things that I think were vetted extensively are, number one, once I make a choice, am I stuck with it for life? And the answer is no. You can make the choice one way today and 6 months from now some other way. And so there needed to be some paperwork in the file, so if staff wasn't sure, there would be, the form would be consistent in everybody's file. One would say yes and one would say no. So I don't think, are you concerned that the form now creates some implication that it's not an opt-out?
I'm afraid that the form is implying that they have that they're not automatically opted in.
So,
but there is clarification down here where it says an election may be updated at any time by simply executing a new form to replace the current form.
Right.
So that to me is you're
out.
Yeah.
Okay, I have a question. Are you getting, what you're trying to get to mainly probably is the committee meetings, and if they come to a committee meeting, or the committee meeting is 3 hours, or it's 4 hours in length, and then do they automatically get the per diem and the travel expense, or are you just trying to get clarification at that level?
Here's where this is coming from, is from the beginning of this conversation was that there were board members that came onto this board that did not know about this policy. They were given a book that supposedly had that policy in it. I will tell you mine did not, but that had that policy in it. And so during our training, if you remember, we talked about this and vetted this pretty well. My concern here is that hopefully this document that we're recommending to y'all now that with the corrections, the changes we've made to it will be clear to the new board members that they are automatically entitled to this per diem and those stipends based on here. And what you're talking about as far as the committee part, we clarified that in C. to say, and I think we all need to have our attention brought here. C was changed to the mid part of the paragraph to say, to minimize such expenses, committee meetings should be held via teleconference or on same day as scheduled commission/board meeting. Other in-person meetings must be approved by the chair, so that if the committee meetings were held, let's say here in Austin the day prior to the board meeting, those committee meetings, if I'm reading this correctly, they are official business, and we did not confine the time, or we did not define day by any amount of time, but it would be at the discretion of the chair to say if that committee meeting was going to be covered by a stipend, at least, right?
Which allowed the flexibility for the concern that came up, what if the committee meeting is 30 minutes? To simply prevent, we come from all across the state of Texas, and we recognize that we need to be as conservative as we possibly can with the dollars for the organization. So I believe we believe we worked through those issues. Now, is there... I want to be sure the interpretation by everybody is consistently the same. So that's
okay,
the reason.
I have one more question for clarification then from Board Member Fontana. You're just saying this is for us to opt out, and so then it's up to staff to know every committee meeting and when it takes place, and then if they haven't opted out, then you have to say, okay, you had a meeting the Thursday before, you get your $75 and your because you didn't opt out, and that's up to them to figure out who was at what committee meeting when.
Because that would be something that the chair approved or did not approve.
Go ahead, Ms. Warman.
I've opened a can of worms all over again.
I think the purpose is simply to use the form as a tool to notify staff of the board members' choices. You are certainly entitled to receive your per diem as specified in the statute, but we have had over a history of the organization some board members who decline that per diem. And what we were trying to do through the executive committee was simply to find a way so that the board member could give that direction to staff so that we would know on a going forward basis what that particular board member's preferences were. It wasn't to choose to opt in or opt out for that board member, but simply to notify staff as to that board member's specific preferences.
And you're not going to be making those options necessarily on every committee meeting. In other words, you're going to make the decision when you enter this board, and at any time you choose to change the decision that you've made. I think all we've been trying to do is create clarity because, again, historically, some people took it, some people didn't. There were assumptions made. It created a lot of angst amongst the organization, so we're simply trying to create an easy checklist. Okay, yes, somebody talked to me about this, and yes, this is my decision. I think that's all that we had in the way of a goal. And then, of course, to clarify and have the conversation we're having now amongst the board in terms of what your options are and in terms of what our goals are. And that's the reason you see all the narrative language ahead of the chart.
And I think it does bring clarification, and you don't take per diem, you do take per diem. You don't take travel expenses, I think you need to have that clarification and not ask the staff to track it. And I think we should make everybody fill out the check the box.
Yes, sir, Mr. McAnally?
I think we also need to keep clearly in mind is whether whichever box you check, I mean, that just goes in the file because any kind of expense that you're going to get reimbursed on, you have to make a claim. That's where it all gets initiated. So don't leave with the thought, well, staff's going to be sorely confused because they're going to have to run through all these forms. No, they're not going to do anything until you make a claim.
Right. That has been the other confusion. And so you do have to submit, in case there is confusion. If you are going to submit for travel reimbursement, you have to submit the proper documentation. You have to fill it out. You have to sign it. You can't just call up and say, hey, I stayed at the Sheraton last night, and my bill's $200, send it my way.
And I think, too, then, that if you didn't travel, but you attended a committee meeting, you were from Austin or close enough in, you didn't have travel expenses, then it's clarification. If you want to be reimbursed for the committee meeting, or you don't want to be.
Correct.
And if you go, years ago, well, I never got reimbursed. Well, you didn't tell us you wanted to be reimbursed for your committee meeting, so.
Okay. Any additional comment? Question? Floor is open for a motion.
I will make a motion to accept the recommendation from the Executive Committee as it pertains to this board member per diem and travel expense.
We have a motion for approval. Is there a second? Second. Mr. Beard makes the motion. Mr. McAnally makes the second. Any additional discussion?
I have a question, Madam Chair. When is this going into effect, presuming that we vote in favor of this? Are we filling out forms today, or is this going to be mailed out to them? There they go.
Mr. Slagle has the forms in hand, so I guess
Before you
today.
leave today.
And we return them to you?
Please.
Any additional questions? Yes, staff is on top of it. I felt like that needed to be said into the microphone. All those in favor?
Aye.
Anyone opposed? Agenda item number 20D, assuming I haven't skipped anything again. Discussion and possible action and so now you know why I passed it over before, right? No, I'm teasing. Recommendations from the Executive Committee regarding the ASB program about drop shipping USPAP to Texas appraisers. Again, passed back to the Executive Committee for full vetting of the issue. One of the things that we looked at was the actual cost. And I believe Mr. McAnally did a pretty good job of abbreviating the discussion in our report. So the floor is open for discussion.
So, and I'm trying to understand that you want to do this?
No, sir. The recommendation is to take no action.
Okay. So moved.
To not drop ship.
So moved.
So moved. We have a motion. Is there a second? We have a second motion from Mr. De La Garza, second from Mr. Barba. Any additional discussion? All in favor?
Aye.
Anyone opposed? Motion passes unanimously. It carries us to agenda item number 20E, discussion and possible action on recommendation from the Executive Committee regarding procedure for adding items to the agenda. Again, this is a topic of conversation that has been ongoing over the course of maybe the last couple of board meetings. And we had adopted a policy in November of 2013 that allowed any board member at any time to put an item on the agenda. At our last board meeting, we recognized that that was problematic because there was specific request of language and how something arrived on the agenda. And so we felt like two things would be accomplished if you returned to the previous action, which is in order for an item to get on the board agenda, you'd simply make the request of the board chair. If for some reason the board chair was non-responsive to your request, you would simply get a majority of board members to support your request, and it would be placed on the agenda. It allows for the chair to actually form the agenda as opposed to putting that responsibility back on staff. It appears to me that that's been the desire of this board, to drive the agenda as opposed to making it the responsibility of the staff. And I believe that's what this memorandum would accomplish. Questions? Hearing none, floor is open for a motion.
I have a question. I'm looking at the wording, and consistent with Robert Rules of Order, not a problem. A board member may add an item to the board agenda with approval of the board chair. I don't have a problem there. But the word or a majority vote, I have a problem with that.
The word vote, maybe, or a majority.
Majority.
Request, or so.
If we could be more specific, if two or more board members.
I'm sorry.
Yes, Madam Chair, that's what I was going to say. It's in Robert's Rule of Order, but when you say majority, it'll be the majority of whoever's present at the time. If you don't have all 9 members, it'll be, but you still have a quorum, it could be something less than 5, it would still be a majority.
I would, you see, that's confusing to me because it's, that to me reads that you need 5 people to consent to put an item on the agenda. And I think that's way too many to put on the agenda. If there should be the creator and someone else, you should be able to put that item on the agenda.
That item's open for conversation. Let's talk about it.
Yep.
I mean, certainly structure was what we were looking for, certainly being able to follow a standard practice or process, and that was the reason for the Robert's Rules of Order language.
And I think that was the intent back when it was voted on initially, about being able to place an item on the agenda. And so...
Would it be a problem to amend it to the wording that Mr. De La Garza is suggesting?
This is a board memoranda. I believe we have the authority to create the document, so as long as it's clear, I think, is the issue. I believe, again, the practice that created problems for us was allowing a single board member at a single board member's request to be able to submit. Now, the interpretation of this is certainly, Mr. De La Garza is pointing out, maybe too excessive. You don't want to have 5. What's the right number? What's the right number of people that need to feel confident?
I had a further question. When it says a majority vote of the board, that would imply that you would have to get an agenda item approved at the previous board meeting and voted on by the majority of the board. So
that's correct.
So the only mechanism to add one after a board meeting would be with the approval of the chairman.
That's correct.
Or vote at the next meeting.
Or vote at the next meeting.
Bring it up. Get it approved.
If I may add just a little bit of commentary, my past experience on other boards has always been, public boards, has always been to be able to add an agenda item to the board. I don't know the history here, and obviously I'm ignorant of the problems that gave rise to this issue, but the way that it was cured, in the event there was a conflict in wording, is the executive director made the decision how the item's going to be posted in the story. So if you wanted to say, well, we want to discuss this with the attorney in executive session, with or without the attorney, well, the executive director made the decision exactly how it's going to be worded. But I want to discuss this with the attorney or whatever. I want to be able to go into executive session. And maybe that's a poor example, giving some recent comments. But my point being that I do enjoy, and I have always liked the fact that I've been able to add matters to the agenda by being a board member. And there was a conflict in the way the wording was phrased out. The matter was settled by staff, specifically the executive director.
And that's been and I realize you're not familiar with the history, but that's been problematic in the past. So I think that's part of what we're trying to vet is who's going to be held ultimately responsible for the words and the way they're said on the document. Secondly, just simply management of issues. And I'll give you an extreme example. If there is a particular board member that, and we haven't had this, okay, so I'm not implying that we have, that maybe this week I want to know how many appraisers are in Asia, and next week I want to know something else. Is it the desire of the organization, the board as a whole, to take up those things, or do you want to have a voice in whether or not that's a productive use of your time?
If I might, with your permission, yes, Madam Chair, just offer 2 additional reasons to have a more structured way of adding items to the agenda. These are 2 very, very common things that happen. A board member or 2 board members ask for an item regarding, X, Y, or Z, and the chair has already approved that item in a different manner, and so there's really a conflict between the 2 items. And if the policy is you know, if the policy is very simple, that anybody can add any item to the agenda, it bypasses, one, the abilities of the chair to manage the agenda, to shape the items so that, in fact, and the chair does this routinely, works with general counsel and the commissioner to make sure that, one, it's completely within our jurisdiction, that it's phrased in a way that we're actually considering things in a manner that we can consider them, that we're not exceeding our charter, if you will. So deconflicting those potential topics, and then shaping, as Mr. Barber suggested, shaping the language of the agenda items so that it falls squarely within what the board is charged to do, and the potential for appropriate action by the board is another issue. And then the last one is that for a public meeting, of course, the agenda has to be published, and we do this, 10 days before in the register, and the potential exists and has happened in the past for a large number of fairly undefined items added on the very last day, when there's absolutely no time for staff to prepare anything to talk about those items productively. And so so those are the kinds of things that if you're going to have a policy other than the chair managing the agenda, what this suggests is that if you have an item that one board member feels very compelling, you bring it up. There's always on the agenda potential future agenda items. And so if you raise the issue and you want to make sure that it's on the agenda, you simply call for a vote. If the chair doesn't say, I hear any objection to that, no problem. Okay, that's with the chair's approval, done. It's on the next agenda. If the chair says, I think that's a problem, and you can call for a vote right then, and without violating open meetings to get a majority of people to agree, we're now in an open meeting. You can call the vote right then and get it on the agenda, and it will be dealt with. So there's it's not a matter of limiting the agenda. It's a matter of shaping and keeping control over the agenda, which is the chair's responsibility.
I will echo those concerns. We did go through those. You think there's these unusual cases or circumstances. You do have to have the structure. You do have to have it. It does have to go through one central system so you don't have all these agenda items that are they're the same thing coming from different angles.
And I think I think, no doubt, the memoranda needs to address the issues that might come up that don't exist. For instance, I believe I've publicly stated on more than one occasion, if you think it's important enough, I've not yet heard a board request that wouldn't just simply pass my muster the minute you ask me for it. I'm not going to promise that's going to always be the case, but I'm going to tell you I've been in public service for about 20 years with that responsibility at different levels, and I've never found an occasion that I needed to say to someone, nope, what you think is not important. So I suppose you could consider that, and then if the structure changed someday and you were in a position that you had a chair that felt differently, that didn't really think anybody else's input was necessary in terms of the agenda, you could address it. And that's the purpose of the other opportunity, is simply to open the door in case you do have a chair that refuses, that doesn't want to listen to what the board wants.
And I think, if I may add, the intent, while we have recently gone through some harsh experiences with agenda items, we are still board members, and we still have the authority to request and place items on the agenda as far as I'm concerned, as an opinion. The structure of going through a chair to put an agenda item, I don't have a problem with that, but to limit it to saying that you need, if the chair doesn't approve of it, and I really want to get an agenda item to say that I need a majority of vote to get it on. And the reason, and part of this is because we have so much distance in time between meetings that what may be important this week or this coming week, I may want to address it quickly, and I want to make sure that it's placed on the agenda for discussion at the next. And again, it comes more to a discussion rather than an action, because if we do need to take an action, then we need to formally put it in the agenda. So what I'm saying is, while I enjoy the opportunity to call and say, I'd like to discuss this, which I've never done in the 7 years that I've been here, 6 years that I've been here, I still want to have that option as a board member to say, I want to discuss this item.
And I appreciate that, and we know from whence this came, but I would simply caution us all that I want the board members to drive the bus. I want the board members to be able to express a desire or concern, and I don't want those stifled. I understand. I won't always be sitting in this seat. But Mr. De La Garza, you sat here. Mr. Beard, you sat here. And I'm sitting here. And I know from practice that I never called you and said, Mr. De La Garza, I'd like something on the agenda, and you said no. I would just simply ask, has there been an experience where the chairman failed to agree with or recognize or
Yes.
Or create?
Yes.
Okay. Now, I certainly know that I was responsible, at least at the last board meeting, as it was pointed out, not styling something the way someone wanted. But that came from the past actions of, receiving large number of items at a very last-minute setting. That creates a problem in terms of communication. So I don't want to be here till 7. So I'd like someone to decide, or let's start the conversation with how many people's the right number of people, and how do we do that without violating the law? So how do we do that? Because if you have to have more than one,
yes,
then you have to be able to make a phone call.
Yes.
If I understand the concern about majority, because we do then become, an issue of walking quorum. So what's the right number?
Madam Chair, I don't know. I'm listening to everything that's being said, but I don't see a problem. I'll just go ahead and say that it be exposed to a majority vote of the members, because what you're doing then is you're letting the board make a decision, and that needs to be, in my opinion, a majority of people that want to hear, that think that issue is important enough to be on the agenda. Remember, we're not even voting on this unless the chair is refusing to put an item on the agenda. If that, and I just envision that's going to be a contentious issue. So if it's contentious enough, I think it's best if the majority of the board agree with that agenda item, rather than just one or two people.
What if it's not contentious? What if it's just a timing issue? What if, like Louise said, something came up 3 weeks prior to the board meeting, and Jamie's got a full slate? I mean, she's done. Her agenda's full. What if it's more of a timing issue?
Well, the agenda would never be full because the chair's controlling the agenda. So while I understand, maybe the better example would be Jamie just didn't think it was important, is really the question. And then the exposure would be, so remember, at that stage, you're within whatever distance from the board meeting. At that stage, it would be called for a vote at the next board meeting. And we've got a ton of background and experience. My past council experience was it required 3 people, which essentially represented, there were 7 council members and the mayor. So if the mayor was refusing, you could assume he wasn't available for the vote, and it left you with 50% of the others. That's essentially, so is there a better way?
Well, to answer your previous question, how many people, I think it would be the creator and 1 other board member.
Okay, so there's a recommendation for 2.
Yep.
Is there a problem with there being 2 from a practical standpoint?
Just if there's a, on the notice, so less than a majority leaves unanswered all of the other issues, okay, which is shaping the agenda item to make sure that, in fact, it falls within our jurisdiction, deconflicting it with other items on the agenda, and the time frame. So if it's not done at least 3 weeks prior, then there's no opportunity for any really staff research to get anything prepared for the item.
And I understand what you're saying, but what I'm trying to say is that this is an item that you want to bring for discussion.
You're not expecting action, is what you're saying.
You're really not expecting that action because you need to formalize it, and I understand that.
So you would say, if I hear you, and I want to understand if I'm hearing you, consistent, let's see, a board member may add an item to the board agenda with the approval of the board chair, or may add an item for discussion only with one or more other members.
And I wouldn't use the word only, but I would use for discussion, to see if it's something that we need to put on the following agenda.
So and again, I think that exists. When I get to the end of this meeting, I'm going to say.
But that's not what I'm reading. That's my point.
No, wait just a minute. I think it exists at the end of this meeting. Is your concern, Luis, simply something that might crop up between the end of this meeting and our next meeting?
Yes.
Okay. Yes, ma'am.
If you require less than a majority vote of the board, then you create the possibility for a walking quorum because you have to have that board member talk to and agree with whatever number the board comes up with, and perhaps he calls or she calls a couple of members who agree, yes, I want that on the agenda, but then the next person they call says, no, I'm not prepared to discuss that, or, I think it needs some more review or vetting. And so how many do you have to call to reach whatever the number of board members is that the board settles on?
And that's why I'm suggesting 2.
So he's making the presumption, and understand the confusion or the problem. If you call 4 of us, and before you get a yes, now you've created a walk-in quorum. If nobody else agrees with you, you've created a problem for the organization.
At that point, it dies.
So we're going to make a deal that says if you make 2 phone calls and it doesn't, it doesn't meet the muster of the 2 people you picked to call, that you're going to stop calling?
Yes. That's
okay.
There's no, you can't get a second, and that's it.
I see that as problematic in terms of how you actually can control the board members' action. I mean, I trust all of you all to stop when you say you're going to stop, but you understand the distinction of the confusion or the problem that it creates?
I'm just trying to make sure that we as board members can continue to have the right to be able to bring items to the agenda.
And I think that's directly relative, and it's unfortunate that it is, but it's directly relative to who's sitting in this chair. And, if you, for at least now, if you trust that if you call me, unless you're just completely lost your mind and are asking me about the NASCAR race, and I'm saying I'm not going to put that on the agenda, I can assure you, if it's something that it concerns any one of you, it's going to go on the agenda.
I would just then, so we can move it along, I would just remove the majority vote then and just forget it.
With the approval of the chair only?
I mean, that's basically what you're saying.
Well, it gives you, do you want the option for, because again, I've already stated, I recognize that I won't be the person sitting here forever. You need to try and make the memorandum match something. I think we're worried, and maybe maybe I'm not sensitive enough. I think we're worried about something that's probably not going to happen, but
it has happened. But that's okay. We're trying to just set at least a parameter to work, and I think we need to move forward on this. So, what does the word majority vote mean? That you need 4 people or more to agree with you?
It's got to be, now I want to be sure that you understand that it's got to be present, so you've got to do it when we're all together. You've got to kind of vet those things that you think are issues, and most of the time, quite frankly, we know way in advance of even the next agenda. It would only be something really unusual in the marketplace that caused us to suddenly have a rise of concern about something in particular.
I'll do what the board wants, but I'm just saying that you're taking away the board members' ability to say, you know what, I'd like to discuss this.
I understand. That's not the goal.
That's the way I'm reading this language with the way it's being presented.
Well, the goal is not to quieten the voice of the board, individually or collectively. I just don't know. I'm trying very desperately, Mr. De La Garza, to do what you want and keep us legal. That's all. The only blocking you see from me is simply, how do we do it and stay legal?
I agree. And I thank the chair for allowing me to discuss this and to give us all the opportunity to express our concerns. You know, but we do need to move on this.
It was my understanding that council gave us an example of what we could do. We could have 2 people, as long as we note that at X person, we have just established a walking quorum, and we have to, it dies.
How do you control?
Well, the issue becomes how do you control that? You know, do you call just one person, or do you have to call 3 or 4 people to get the requisite number of members who agree to add the item to the agenda? And just as a point of clarification, the board's rules in Rule 153.3 state that the meetings will be conducted in accordance with Robert's Rules of Order. And Robert's Rules of Order provide that the agenda items are added with the approval of the chair or a majority vote of the body. And that has been the way the board has historically operated until the policy was changed in November. And prior to November, there had been no problems with operating in that manner. And so this, as I understand it, is simply a return to that prior practice that is spelled out in the board's rules.
If I may, Madam Chair, I don't have a problem with the proposal. I think we were dancing around something that was completely, really irrelevant. I mean, Mr. De La Garza wanted to reduce it from a majority to 2, but there was a problem with a walking quorum. Well, actually, he would reduce the risk of a walking quorum from going from majority to 2 because you're no longer soliciting a majority on the phone, but you're soliciting only the 2. And a walking quorum is a problem that we always have to self-regulate. So it doesn't matter whether it's for this or anything else. Everybody has to do it for themselves to know that I can't go around trying to get a majority of people to talk on any given agenda item topic. So I don't really see those as. I understand the legal advice, but I don't see them as valid demurrments of why we can't move forward with the proposal Mr. De La Garza was making. That being said, I don't personally, and I feel I have to say this because of my prior question, I don't have a problem with the returning of the practices to the way things were prior to, was it 2011?
2013.
2013.
Madam Chair, not to bring up, I wanted to point out, is there a reason that there was an omission also of placing the item on so long as it is jurisdiction and not an issue currently in litigation with? Is there a reason that we omitted that from what you're presenting today?
Not to my knowledge. Is there a reason we left that off, Kristen?
No, there's
It was curiosity. It's in the memorandum dated November 22nd, 2013, but it's not in this proposal.
If I might address that, the reason that it's no longer there is that the chair the chair always consults with general counsel on the shaping of the agenda, the setting of the agenda, if you will. And so that procedure is already there. It was only made necessary when the chair no longer had the check, if you will, of well, when anyone could add anything to the agenda at any time, there had to be some additional controlling language. Because it is true, obviously, that that General Counsel is never going to let the chair put something on the agenda or suggest that, no, they're going to negotiate that language to make sure that it otherwise fits within those constraints.
All right,
That's why.
understood. Thank you very much for that clarification. So, Madam Chair, if I may try to make a motion on this.
Yes, ma'am, the floor is open.
May I move to accept this memorandum presented by the Executive Committee and all the language with this particular language being changed to consistent with Robert's Rules of Order. A board member may add an item to the board agenda with approval of the board chair or two board members.
Madam Chair, does Robert's Rules of
Wait,
Order
just a second.
require a majority?
Hang on just a second. Can I get a second so that we can go to discussion?
Sorry.
Second.
I have a motion by Ms. Fontana and a second by Mr. De La Garza. Now the floor is open, Mr. Beard, for your question.
My question is, Robert's Rules of Order does require a majority, right? So you can't leave Robert's Rules of Order in, then, if you're not going to be consistent with Robert's Rules of Order.
And Madam Chair? Madam Chair?
Yes, sir.
And may I also say that that's complicated by the factor that our General Counsel just read out of Chapter 153 that our meetings are conducted in accordance with Robert's Rules of Order. So you'll be violating your own rules.
We have the option to be able to add even without the Robert Rules of Order, right? A board member may be able to add an agenda item without the Robert's Rules of Order.
I believe, and I'm just going to throw this out, I believe that since the rules state that the Robert's Rules, unless by rule, it's changed. So I think that we can't ignore the rule by policy. We can override the rule by rule. Does that make sense, and is that true?
Yes, that is correct. Rule 153.3B of the board's current rules state that meetings of the board may be called by the chair on a motion by the chair or upon a written request of 5 members. Meetings shall be conducted in accordance with Robert's Rules of Order.
Madam Chair, so does that make the motion moot?
I'm working on trying to style something that I think accomplishes what the goal that I hear being discussed, or at least by some members being discussed, and I'll try and give you. So here's what I hear you saying. I hear some of you saying that you'd like the motion to look something like: a board member may add an item to the board agenda with the approval of the board chair or at the request of 2 board members. And I almost feel like it then needs an asterisk at the end of it that simply says the board members are cautioned to observe the walking quorum issue and or concern, so that people that aren't familiar with formalized processes at least have some kind of footnote that they need to be cautious, because again, what we've talked about, Mr. De La Garza, in order to avoid the only reason we have it the way we have it is to avoid the walking quorum. You'd almost be promising that I'm only going to make 2 phone calls. If I'm not successful with 2, I'm going to drop the issue or start calling the chair again. I got to tell you that I can't imagine there's a setting that
the maker of the motion. I don't know if it's something that.
Well, I just said we're in discussion now, so all I'm asking is that what I hear you saying you'd like?
I mean, if I like the board chair and I like the 2 board members. That's I don't have a problem with that. Now, the other language, I don't know how it's going to work or what you need to add or subtract, but that's...
No.
You're saying we can't do it because of the Robert's Rules of Order?
Yeah.
It's the board's rule that we operate under Robert's rules. We cannot, by policy, violate our own rules. You could propose a rule change that would, that's the only way you would have to go about that. So this policy, in accordance with Robert's rules, is more informative. This is the way we've done it since the birth of our existence, all the way through November the 22nd, when we adopted a different policy that, frankly, we didn't have the authority to adopt. So we're returning to Robert's rules. Now, if you want to adopt if you want to change the rule, I believe you can do that. But I don't think we can do that by policy.
Let me make a recommendation. It sounds to me as if we would be best served if we return to the actions that have worked for us until a short period of time, that you keep in mind, and I'm glad we're having this conversation because it allows the board to be fully informed about this particular issue. And if you find yourself blocked from being able to discuss something that you want to be able to discuss, that you be prepared at a board meeting to get that taken care of. I do not believe for at least a few more months that you will have an issue ever getting something on the agenda. And so if we find it problematic, it gives us still an opportunity to continue to try and explore options, maybe even recommending a rule change if we feel strongly enough. But I would suggest that we not adopt something that's against the rules we currently have, but that we either vet it back to the executive committee to maybe propose some future change in the rule, but to maybe accept this as the interim.
If Ms. Fontana retracts her motion, I don't have a problem with that.
I retract my motion on the floor.
Motion on the floor and the second have both been removed. The floor is now open for a motion.
I will make a motion that we accept the recommendation of the Executive Committee pertaining to placing an item on the board agendas.
We have a motion. Is there a second?
I second it.
We have a motion and a second. Further discussion? All those in favor?
Aye.
Anyone opposed?
Aye.
Okay. Mr. De La Garza, the opposition? Okay.
Yes.
Thank you very much for that very good conversation.
Madam Chair, can I make a motion to propose that we change the rule? The Robert Rules
Can
of
you
Order?
let me do that in the proper order on the agenda?
Sure.
Will you write it down on your other business? And we will certainly, item number 25, I will try very much to remember to come back to you on that. Agenda item number 21 is discussion and possible action regarding submission of comments to the Bureau of Consumer Finance Protection and other federal agencies regarding proposed federal rules for the AM. Oh, wait a minute. No, I'm all right. Federal rules for AMCs.
Madam Chair and board members, on April the 9th, 6 agencies of the federal government published the rules, proposed rules for the state regulation, the minimum federal standards for state regulation of AMCs. Okay, these are the long-awaited final rules, the proposed final rules. We've been operating under interim final rules since November of 2012. I have begun the process of reaching out to our stakeholders. We've read through this, made notes. General Counsel has read through this and made notes, and we've begun to reach out to our stakeholders and the other states. And we plan to prepare a draft set of comments that will be vetted fully by the AMC committee. Okay, so the advisory committee is the appropriate place for that to be finalized. And so I just wanted to give you a progress report, let you know that the comments will go out on behalf of the board from the advisory committee, unless you change that process and ask that, certainly that the chair would would look at it as well. But the meat of those recommendations will not come from the full board, even though it'll go out in the board's name, because the hard lifting hasn't yet been done. And so it will be done on May the 22nd. We have until June 9th is the deadline for filing the comments. And so that was the proposal, or that is the recommendation of staff. That's our plan at this point, unless you direct us differently.
Thank you, Commissioner. Questions? This is slated for discussion and possible action. Is there action?
Do you need a motion to accept his recommendation?
I would think so.
I will make a motion that we accept staff's recommendation on addressing the, making the comments back to the Bureau of Consumer Finance and Protection Agency on our rules regulating the AMCs.
A motion by Mr. Beard. Is there a second?
Second.
We have a second by Ms. Fontana. Any discussion? All in favor? Aye. Anyone opposed? Motion passes unanimously. It takes us to agenda item number 22, which is discussion and possible actions on recommendations from the Budget Committee regarding the draft 2015 budget for the board.
So, board members, you have in your materials the proposed budget was proposed by the staff to the Budget Committee this morning, and you heard from the chair that they asked all of their questions and were generally positive about the budget. You also received a copy of the budget development policy that this board adopted. And so you see the various deadlines that are in there and the description of the process. So I want to, at this point, essentially do a summarized presentation of the budget and then answer any questions that you have, and then simply encourage you to, as you think further about this, to get any questions you have or concerns that you have back to myself or the chair of the committee, so that we can develop those parts of the budget that may need additional work. And I'll try to identify some of those that we anticipate in my presentation here. So if you will turn to the budget there, I just want to hit a few highlights. You'll see that in the salaries and wages category, we're actually proposing less money than was approved in the 2014 budget. That's because we have one less investigator on staff. So while this budget includes a 2% cost of living increase, that's consistent with what the legislature has mandated for all agencies in Texas. And then it has another 2%, which is the discretionary, so we can provide incentives and recognize exceptional work and classify people appropriately and pay merit increases where they're appropriate. That's what that other 2% is for. When you put all that together, we still actually come out slightly less, budgeting less than we did previously. Okay, the employee benefits are simply a percentage of the base salary plus one additional item, which is the retiree health care. So, for example, Ms. Beverly Arnold retired from this agency, and she was dedicated to the board, and so her retiree health care will be paid by this agency as long as she lives. It's one of the things that we do, and so that's allocated back to the board. Those kinds of things are included in that category. Other personnel costs, we anticipate, when we do expenses, we try to do kind of a worst case scenario, and so we assume or we anticipate that everyone is going to ask for everything that they're entitled to. So if every member And this consistent, of course, with the change in policy, if you will, on the committee meetings. But if everyone asked for every per diem that they were entitled to, we have money to cover all of that. You're entitled to it. If you ask for it, you will get it. And so that has gone up, because that wasn't always the policy. Professional services, we've gone down a bit in changes planned for our database system. Many of the other items, we talked about the office rent and the SWICAP. The reason that office rent is shown going down, Ms. Huerta talked about in the budget status report, because that's offset by the SWICAP number. Well, until the governor's office and the facilities commission agree what they're going to do going forward, we're simply believing they're going to do what they did this year. So we'll pay less rent and more SWICAP. That's why it's shown that way. And if in fact that is resolved prior to the August meeting, the new budget will reflect that. Will reflect the actual rent and the amount of the resolved SWICAP. Many of the other areas have gone down or stayed very flat. As we continue to do more things electronically, we need less postage and paper and copiers and all those kinds of things. So that's the expense side of the budget. Are there any questions about that? Just off the top of anyone's head? Okay. On the revenue side, we have only 3 categories of revenue. License fees, so license initial and renewal fees by appraisers. Registration, initial, and renewals by AMCs, and then miscellaneous revenue, which is a very small number, bad check fees and exam fees that we get from our exam vendor. Okay? As you may recall, this agency came into being in 1991, so that's an odd-numbered year, and so we had a whole bunch of appraisers started in 1991, and fewer in 1992. Over the years, those numbers have, so we had a large amount of revenue in one year and a very small amount the next year. Very much like we find ourselves today with the AMCs. So in the even-numbered year, 2012, 181 registered. Well, we're only up to 192. So in the odd-numbered year, we only had, 11, 12 more. We have 199 total, and we've lost 7. So we expect consolidation, but it's heavy in one year. And so you'll see the very last item in the revenue is carry forward. We essentially take a large amount of that money and carry it forward to the next year, because we don't recognize all the revenue in one year. We recognize it in the following year because we have expenses related to that in that year. So that's why that is structured the way it is. So you'll see that this budget actually predicts an $18,000 to the good so far. One of the very things I wanted to point out on here is if that column that's right next door is we estimate per the policy, we show 2 full years plus the year that we're in, estimated through the end of the fiscal year, then the proposed budget year for next year, and then just a pro forma, if you will, budget out for 2016. So you're always looking at 5 years worth of potential financial information when we do these budgets for your consideration. So if you'll recall, we approved a budget last year that was almost $52,000 in the negative. But believing that we needed all the resources that we had and time would provide other opportunities, we kept all of our resources. That was a wise decision. And in fact, at the end of November, one of our appraiser investigators left us, and so we saved his salary for the rest of the year. We did not replace that position, didn't hire somebody into that position, and we don't need it Right now, going forward, we're closing more than we're opening. So we're projecting that not to be in our future. And as you can see, projecting we're going to be $81,000 right now. If everything works as we think, at the end of August, we'll be $81,000 in the black instead of $52,000 in the red. So that was it all got taken care of. So that's the budget. If you look at the second page, this is consistent with our policies, two other policies that the board has for us, one with respect to maintaining an operating reserve, and the second with respect to our investments in it's called the trust. It's not really a trust, but the state agency that acts as a banker for us, if you will, is called the trust. So they're total cash available. I want to focus on essentially the white numbers there. Total cash available at the end of March. You can see that $543,000. And then other activity, net activity now through the end of the year shows another $196,000 to the good. And that's excess revenues, if you will, from the timing of the renewals of AMCs. So we're projecting that we will have, at August 31, 2014, about $740,000 available to us. Now recall that for 2015, $302,000 needs to be carried forward for the next year, okay, for operations. And so if you restricted those funds and said we're going to recognize those later, so subtract that 302, that leaves you at about 437, right? 437. Our total budget is a little over 1.6 million, 1.628. So $407,000 would put us at 3 months worth, 1/4 of that. So we're just slightly ahead of our 3-month target in terms of operating reserve. So we're on target. We're not falling off. We try to be very conservative with all of these numbers, but I wanted to explain that it's not like, oh my God, look, we have a bunch of money there. Well, we don't really. It's in the bank, but it's carried forward for future expenses. In addition to, we're pretty much right on target with our reserves. So, any questions about either the income side or the cash flow projection? Okay. If not, then I want you to feel free as you work with this budget and think about it to send me any questions that you have, because I want to make sure that all of the board members have the opportunity when August rolls around, there's no surprises. It's like, well, we should have thought about this that we didn't think about. Don't want that to happen. So the Budget Committee, if there's serious issues that come up, the Budget Committee can be called into a teleconference at any time with appropriate notice by the chair. Otherwise, they will meet in person before the August meeting. But please look at the policy, and even if you miss one of those deadlines, if there's something that you think of that you would really like to know, please feel free to send that information. Send those questions to me, and we'll answer all of them. Okay.
Mr. Beard, did the committee have any specific concerns about the budget?
No, we didn't. We got all our questions answered, and we seem to be right on track. And we talked about how the monies are invested and what other opportunities do we have in that respect, and that was all addressed. I don't know if anybody else had any other thoughts that we, to my knowledge, we got our questions answered. And
very good. Is there specific action that needs to be taken on this agenda item? I suppose I haven't heard any particular recommendations by the Budget Committee. That's what I'm trying to be sure of. Have you made recommendations that the board needs to be aware of?
We
So
don't.
other than receiving the information, you're not looking for any direction at this moment?
No, we're not. We're encouraging the rest of the board to, as the commissioners pointed out, we handed out this budget policy to be advised. We're going to go hard on this in August. So if there's any questions, need clarifications, now's the time to get those answered.
This is, yeah, absolutely. Between now and August, please feel free to reach out to staff or your budget committee, which is Mr. Beard, Mr. Padden, and Patrick, who's been quiet over there on me today. Mr. Carlson. Okay. That takes us then, if there is no action needed on the part of the board, then that takes us to agenda item number 23, discussion and possible action regarding the agency's strategic plan for 2015 to 2019. And before you begin, Commissioner, let me just note for the record that Mr. McAnally has had to leave the dais and has been is not present for future action until so reannounced.
Okay. Well, board members, I included the report in there, and let me just summarize a couple of points about it. This year, the strategic planning will be done a little bit differently than in prior years. Normally, we would already have a draft of that. That would have to go through significant revisions and then subject to the approval of the chair in order to get it delivered in time per leadership's request to get it done somewhere late in June. Well, as an SDSI agency, we have confirmed with leadership that we're not actually required to do a strategic plan. We're going to continue to do the strategic plan because there's lots of great benefits from doing that, but it actually allows us, we're recommending that we change the calendar, if you will. So with the budget development process and the strategic planning process proceeding apace, we'll have a draft for you at the August meeting. That's our plan, and then deliver both our budget and the strategic plan with those budgetary priorities reflected in it to leadership by September the 1st. So that's the principal message that I wanted to deliver. Secondly, I wanted to highlight a few things that came out of our listening tour. And in the report, of course, this is a joint plan, and so many of these things have to do with the real estate side, but there are several. Continuing the work of the Education Standards Committee, so this is under the bulleted items there, Inspector, Legal, and SOP course, and this is really, there was an acknowledgement that there is a need for Texas-only continuing education for appraisers. So that's something that the Education Committee, after having dealt with the supervisor and trainee course that became mandated by AQB, it has still on their agenda, and so this is a ringing endorsement that course should be developed. As well as for those mandatory kinds of courses, there was actually a hunger out there for courses with meat on them that were taught by people who had the appropriate training, and that everyone who had so you had good, well-prepared instructors, both knowledgeable and in the techniques of teaching adult education. So considering specific courses for preparing instructors and training them, and then also having some of that material be evaluated, kind of a mandatory evaluation. In other words, if it's important enough to make it a mandatory course and to train people to teach it well, shouldn't you also ensure that people learn it? Okay, so evaluating classes. Allowing, as consistent with discussions that this board has had for a long time, allowing agency board members and staff to teach classes that are offered for credit, especially the ones that we write, and then continuing education classes, as you are all well aware. If I or one of the enforcement attorneys goes out and speaks to a group in the middle of their education day, that hour that we spend with them, they can't get any credit for. Because there's no authorization in our statute for that. So we got a ringing endorsement from the field that, yes, they want that hour of credit. And so get that changed, would ya? And then the last thing is something that came up, that has come up, and it's part of the kind of ongoing discussion, is on the real estate and inspector sides, administrative penalties that are collected from license holders, part of our disciplinary process, go into recovery fund, okay? And that is then subject to claims. There are several other agencies that have education funds that money goes into. So, consistent with, we don't have a recovery fund. We could establish an education fund that would assist us in justifying, if you will, having these penalties as a part of our operating budget. So they'd be restricted to support for additional education. In fact, perhaps even used to fund the writing of the Texas-only course and presentation of that course. We need the assistance of others. We need some resources for that. Allocating those monies solves several issues, perceptual issues for us with that. And so that was the other kind of big thing that came out of that. And then one other issue that is an ongoing issue that we want to make sure is well vetted as a part of the strategic plan is the potential for creating some limited confidentiality for the work files during the investigative process here in the office, so that we can avoid drafts getting out there because of Public Information Act requests. We can't withhold them, but they get out there and they can be misused, as I think many of you have heard something about. But they can be misused. And so there are many agencies who have confidentiality provisions for investigative work regarding complaints until the board makes its decision. And then it's a public record. It's all subject to disclosure after that. But it's a done deal, as opposed to it's an ongoing working relation or work product that's subject to change, and that has wasted a lot of time for board resources dealing with issues like that. So, creating a confidentiality protection similar to what some of the other state agencies have, we'd like to see that in there as well. So, many of those issues will be suggested for the enforcement-related issues to the Enforcement Committee. Executive as well will help. We need your help vetting those ideas, shaping those ideas, and then they'll be included in the final report that comes to you in August. Any questions about the process?
Commissioner, because this is an agency strategic plan, obviously it involves both TREC and TALCB. Do you have somebody on the TREC side looking globally at the strategic plan, or is it being handled in bite-sized pieces at various committees as well?
It's being handled by various committees, and then the final draft, of course, will go out to the commission as it will come to the board. Would like to get it out before, obviously, at the very latest, it'll get published with the materials for that meeting. But right now, our target is to get it out by about July the 20th.
I would encourage you to attempt to do that, because it sounds to me like it will be a pretty large document and may very well need some time to review it in case there's something that might want to be vetted at a committee level. It'll still be tight timing-wise, but lots of work there.
Yes.
Doesn't appear to me to need any particular action. Are you looking for any direction from this board?
I wanted to lay out the plan only to get feedback if you, as you just suggested, that in addition to the kind of the piecemeal work of the appropriate subject matter experts on various committees, that it needs some time for a global review as well. So I take that as an instruction to get it out to the full board as soon as possible for your review. So unless you have other directions for me, or if I misunderstood that, please let me know.
You understood me clearly. Is there any other comment or questions? Hearing none, we'll move to agenda item number 24, discussion and possible action regarding alternatives standards for evaluating required experience for certification.
Okay, this came up, and I'll just a very brief story. So we had two folks who have applied to become certified appraisers. They were once certified appraisers for a long time, in the 90s or whatever, and then they went to work for a bank, or one was a lady who decided to have a family, to have children, all that stuff. And so neither one has had a certification for 6, 8, 10, 12 years, okay? So they send in their applications, and it's like, oh, well, you know, I could see you had these hours and you were certified once upon a time. We'll need some work logs because we need some reports to review, because AQB requires us to make sure that the experience that you're claiming is USPAP compliant. Well, we're way past the time that any of these records exist. There's no requirement to have the records anymore. Okay, so we're now at an impasse. Through no fault of your own, those records don't exist. You were once supremely qualified. You own the certification that, in fact, you want us to reissue to you. How can we determine whether or not you're worth the risk, if you will? Okay, so we began the process by reviewing. There's several excerpts there that has been provided on that memorandum. Our rule, let me just start with, AQB criteria provides a discretion to state officials for determining alternative methods for verifying appraiser experience. And so that's the quote there. That discretion is carried forward in our rules. Evidence satisfactory to the board. So one of the things that was suggested, and we have asked this question, our general counsel has been in touch with our ASC oversight and asked the question. This can't be the very first time that this has ever come up. And it is initial, well, we're going back and forth with them, but at this point it appears that it would be acceptable, if this board wished, to recognize that former credential as sufficient to issue a probationary credential that then we could check. It's like, did you really know? But it would require, and this is one of the other curious parts that is going to require some additional negotiations and understanding. Right now, if you want to be reinstated in a license, which is this is what we're talking about. I want to reinstate my license. If you have been out for 10 years and you're required to have 28 hours, or don't just make it up, so it's a lot easier. 10 years, 28 hours, or 14 hours per year of continuing education, you're required to get all of that education before you can get reinstated. Okay? All of it that you missed. So if you've been out for 20 years, you've got to go get 20 years worth of continuing education in order to be reinstated. That's the AQB rule today. Okay? So that's good news, bad news. There's a light at the end of the tunnel, but there's a lot of there's a lot of obstacles in the way. I just wanted to let you know we're going to continue to work on that. I recommend that you refer this topic to the Enforcement Committee, and we will continue to work with them to come up with something that then they can recommend back to the full board, so you can take action on. Obviously, it's not the last discussion we'll have about it, because there are people who want to become appraisers and were once productive appraisers.
Questions? Comments? Floor is open for a motion. Which might sound something like we recommend this to be referred to the Enforcement Committee for... We can just do that.
Yeah, the chair can just...
If you'd like me to do that, I'm happy to. I'm always wanting the board to have the opportunity to have its voice. All right, let's take us to agenda item number 25, and we'll welcome Mr. McAnally back to the dais. Request for potential future meeting agenda items. Mr. De La Garza, would you please make your request?
Yes, I have one.
Yes, sir.
We entertain the motion, the item to place, not overrule, but to create a rule to have two board members, create a rule that will allow two board members for an agenda item, to place an agenda item. And I'm not wording it very...
No, that's fine. It's certainly fine in terms of the future meeting agenda item. The chair certainly would accept that. I think, based on the long conversation we've had today, let's go ahead and let the board voice it. We've got them all assembled. But might I suggest...
It's a majority.
Absolutely. Might I suggest that the way to vet that, based on the very long conversation we had and our inability to be able to resolve the issue at the dais today, it probably needs to be in a working group somewhere.
Exactly.
So do you have a preference as to who tries to vet it for you? It's probably most appropriately at the executive committee level, unless you
Nope, that's fine. That's
would
fine with
request
me.
it some other place.
I think it's a very appropriate place.
So would the motion be to request the executive committee to take up the item of agenda, let's see, how to place an item on the agenda and or change that rule once again, and hopefully vet that so that it's available for the next agenda. Is that
Thank
what
you,
you're
Madam
looking for?
Yes.
Something like that? Okay, there's a motion. Is there a second?
Second.
We have a motion from Mr. De La Garza and a second from Ms. Fontana. Discussion. We might ask that you attempt to participate in those executive committee stylization meetings so that we are sure we're addressing your concern. So there's a motion and a second. All those in favor?
Aye.
Did you have a question, Mr. McAnally? I didn't mean to cut you off from the vote.
I'm sorry, does the request for an agenda item require a motion or a vote, or?
It does not, but since we fully vetted that issue, that's one way you get items on the agenda.
Okay,
And
okay.
since it was an issue that required so much conversation, I thought I'd give Mr. De La Garza the opportunity to have the weight of the entire board behind him and not simply the chair. So, absolutely. So all those in favor? I believe the only person that didn't fail to vote was Mr. McAnally, who was trying to stop me, and I didn't recognize that. So,
And for the record, I voted against the motion.
okay. So so the motion has a majority vote, and so is there any dissenting vote? And Mr. McAnally, yours is a nay. So we have one against, the remainder for, and the motion passes. Are there any other items that board members would like to see on future agendas?
Madam Chair?
Yes, sir.
And this would be at your discretion if we take this matter up, or where it goes, whether it goes full board or it goes to a committee. But seeing what other lengthy item that we discussed earlier this morning on that trainees case in regards to experience credits, I see a need that we need to give the investigators another tool in their toolbox that they can use to maybe be able to dismiss these things instead of them going through a complaint an agreed order. And so I would like to see if we could study that issue and maybe come up with a recommendation.
Maybe appropriately at the education level? Would you think the education subcommittee is the place to take a look at or enforcement? I suppose enforcement's kind of already received that, correct?
I was going to say, have we received this item before? Is it already something on a pending agenda, or?
Closely related to something that you might be looking
okay.
into. So I see a request for a future consideration for experience credits, and again, the chair has no problem. I'm happy to expose it to entire board vote. Since you're all present here, we may as well. If you'll simply make that as a motion, we'll get you a second, and I doubt that you have a problem getting it passed.
Madam Chair, I move that we add an agenda item for consideration at the Enforcement Committee level to explore avenues of or processes when investigators are evaluating experience credits in order to be able to have a mechanism to dismiss a complaint if a complaint arises through that process.
Second.
A motion by Mr. McAnally, second by Mr. De La Garza. Any discussion? All those in favor?
Aye.
Anyone opposed? Are there any additional items that board members would like to see on future agenda? Keeping in mind you are allowed and certainly have the right to reach out to the chair in the interim for additional items, I would request that you be cognizant of the fact that when you do it at the 11th hour, it's incredibly difficult for me to get it on the very next agenda. So to the degree that you can mark your calendars for, remembering that we have to post 10 days out, maybe mark your calendars for about 10 days before that. It'll give me an opportunity to do the best job in terms of getting language vetted at the levels that we need to be sure our agendas are appropriate and proper. I'm certainly happy to take requests all the way up until the last minute. I'll simply tell you that it begins to reduce the odds of it making the most current agenda.
Madam Chairman, would it be appropriate to add an agenda item at the next meeting to discuss the agenda or topics of discussion for the half-day board member training session to be held at the in conjunction with the November meeting?
Certainly appropriate. If you'll help me, Mr. Padden, because I want to be sure that we understand what you're looking for. Just an opportunity to discuss what the expectations are at the half-day training? Is that?
Yes, or have Mr. Oldmixon lay out what they plan on presenting.
And give us a briefing, and that way we can add topics if we need to. Or okay, very good. I like the idea. Absolutely. Anything else? So the chair will request that just to keep simply increase the efficiency on time. Is there anything else the board recognizes at this moment that they would be interested in on the next agenda? Hearing none, and seeing no other action items are on our agenda, we'll consider. Oh, there's one more. There is one more. Oh, I guess we need the future meeting dates. See, I just keep trying to get you out of here. Discussion and possible action regarding future meeting dates.
So we are currently reserved for August the 15th, as was suggested at the February meeting. However, I sent all of the board members an email with a link to the information about the Appraisal Institute meeting. Their international meeting will be here in Austin on August 4th, the 5th, and the 6th. And just wanted to offer the board members the opportunity. I know that to be in town for that and perhaps attend some of those sessions. And so having, rather than make two separate trips, I know some of the board members are members of the Appraisal Institute, industry members, and may be wanting to attend that. So I just ask that if everyone would look at their calendar and come prepared. We can get this meeting, we can get this room. We have it reserved for Monday, August the 4th. And if it's your pleasure, we could move the meeting to that day, be done prior to the education sessions starting that afternoon at 4 o'clock. Their keynote starts off at 1:30, and maybe we could be done by then. But If not, certainly by the time the education starts. And then if anyone wanted to stay in town for the Institute for the rest of the meeting, you would already be here. Wouldn't have to pay 2 travel trips to come. So that was just a suggestion, and I wanted to make sure you had the opportunity to talk about that.
Can you all look at your calendars and talk to me about your availability on, instead of having the meeting at the previously discussed time, are you available on August the 4th? And are
No.
you interested in changing the meeting time?
Nope, I have a wedding. My son's getting married that weekend, so we'll be tied up.
Well, congratulations.
Yes, thank you.
Okay, that's certainly a consideration. Anybody else got? Does anybody else have specific conflicts? Is there a preference? Do you want to leave the meeting on our predetermined date? Or do you want to try and piggyback it?
How many would like to attend the Appraisal Institute? Does anybody want to go to the Appraisal Institute meeting?
I probably would.
I would like to go, but I don't know if there's anybody else. Public members probably don't want to go, but. And do you want to go? No.
Would it be?
Yeah.
Moving the
You'd go?
meeting date to Tuesday, would you be available, Mr. De La Garza? And I'm not sure whether the facilities are available, but if we were to change our meeting date to Tuesday, would that increase your availability? Is the question at the table.
I'll have to get back to you on that.
Okay.
I have a little preference. I kind of like the 15th that we have. I've got things going on that week of the 4th as well. I mean, not to say that I wouldn't be here if we changed it, but
I understand.
would. But for me, the scheduling of the 15th is still better.
Okay.
I believe.
Well, that's exactly why we're asking. We really do care and want your input. If it's a
We do, can we get the Appraisal Institute to move their meeting?
There we go. Let's do that.
I think that's a great idea. In fact, Mr. Barber, we'll put you in charge of that, right? Go ahead. Okay, it's sounding as if the preference is August the 15th as opposed to altering the meeting date, at least by a couple of members. So, well, I'd like to give staff some direction. So if you guys can give me some help with that, I'd appreciate it. Yeah.
I'm okay with the 15th.
I'm okay either way, but I'd prefer it to be at the one end of the week as opposed to or the other.
The end of the week.
Because it's different.
If
It's
it was
difficult to
at
get
the end of
flights.
the week, I don't have a problem.
Okay. All right, so the preference appears to be August the 15th. We will keep our meeting date.
And then the next third, just for planning purposes, we always do this 2 meetings out. The default is Friday, the 21st of November. Okay, Friday, the 21st of November. So that is the Friday before Thanksgiving week.
And then would there be possibly training on the 20th?
Correct. So that's, we would normally, or we have planned it in the past, so that was what we would propose, is to have our half-day of training on Thursday afternoon of the 20th. Travel in the morning. We're already staying over one night anyway, so doesn't add additional expense that way.
Any conflicts? I mean, there's always conflicts amongst us, but is there a majority of people that have conflicts, or anybody got a concern with those dates?
November 2021?
Yes, sir. Hearing none, then we will preset that as our anticipated date. I'm sorry, Mr. De La Garza?
Just a general comment, Madam Chair. It appears that most of the members are now arriving the day before or have quick access to this place. Barring having committee meetings on the Friday of the agenda, is there a possibility we could probably start at 9 o'clock instead of 8 o'clock?
10 o'clock? You mean start at
That
9 o'clock rather than 10 o'clock?
Yes, start at 9 o'clock rather than 10 o'clock.
Meetings.
Unless there are committee meetings that have to take place or whatever, and I know that's a good time to have them, but If
Certainly
everybody's
open to the conversation. I would say two things to consider, and one is the one you've already brought up, and that is oftentimes, especially with our policy, that we will have a committee meeting in advance of the board meeting. So I'd simply ask, how early do you guys like to get up? And then secondly, that we do have members of the public that do travel here. I know several members come from the Dallas area, and so let's just be cognizant of the fact that we may be asking them to start very early too, but certainly starting a bit earlier I'm not opposed to. It's just a matter of whether or not we can make some practical sense. I'm assuming there's a reason why we start at 10 a.m. Has it just been the history because of anything in particular?
So that it was set that way to encourage, as a cost savings measure, to encourage the committee meetings to happen before then, and then also in consideration of those who do drive in. And I know, we have folks from all over that are flying in, but we used to have folks that were a little closer, but that were driving in. And 10 o'clock, and we had some folks who really didn't like early morning meetings at all, and so 10 o'clock has been it's been a tradition. That doesn't mean it can't change.
Why don't we put that on the future radar? I like the idea and the topic of conversation. Let's talk about how we might vet it out, because I do think if we were to make a change, I want to be sure we do it enough in advance that we can get the word out to the public so we don't have somebody surprised by the change.
And it seems like most of our committee meetings go right up to the, and not that we're sitting around having chit-chat, but we really need the additional time that you wouldn't think you'd need to get them done by the 10 o'clock start time.
Agreed.
Is it possible also to push the public address back on the schedule?
I'm sorry, didn't hear you.
To change the public comments to later in the daily agenda so that they're not right at the beginning?
Sure, you certainly could. I guess that's, again, fine line. If they actually do drive in, I find them to prefer to be on the front end of our agenda so they can decide whether they want to stay for the rest of the meeting. But potentially, moving it somewhere else in the agenda, I suppose that potential does exist, and we can talk about that as well. It's a request to have everyone sign the election form that Mr. Slagle's going to tackle you if you don't complete it for him before you leave. Now, and let me just ask, is there anything else on the agenda? Because I've so far skipped a couple of things and almost closed the agenda before I needed to.
Madam Chair, if I could just say I appreciate your warm introductions at the beginning of the meeting. I look forward to working with this board. I appreciate the orientation yesterday by our very knowledgeable commissioner, and again, I look forward to a very productive service on this board. Thank you.
And you have already been an asset to this board, and we thank you very much for your service. I don't believe there's any other business for this board to take up, and so we will consider ourselves adjourned at 20 minutes until 4 o'clock.